Welcome to the Appellate Division. We have almost 7.5 hours of argument time requested, so please ask only for the time that you need, not the time that you want. We are familiar with the briefs and your records, and if we have more questions, we will continue to ask them. People versus Rivas, appellant.
6 and 2, please.
I'm sorry, what'd you say?
Requesting 6 and 2.
Respondent? 6, 1, and 6. Brook versus Solsman, appellant. Respondent?
And I'm another appellant.
You did one brief, you get one argument.
Respondent requesting 3.
5, 1, and 3. William versus Geneva is submitted. Albert versus Monan Group, appellant.
Good afternoon, Your Honor. Appellant's request 6 and 2.
Respondent? 6, 1, and 5. Banana versus City of New York, appellant. Respondent? 3, 2, and 3. Sanchez versus Bronx United, appellant. Respondent? 4, 1, 3, and 3. Sorz versus Rahmatullayev, appellant. Respondent? 6, 1, and 6. People versus Tolliver, appellant. It's submitted. IS Company versus Olson, appellant. Respondent? 6, 1, and 6. And again, if we have more questions, we'll keep asking. King versus City of New York, appellant. Respondent? 3, 1, and 5. People versus Sabino is submitted. Redder versus City of New York, appellant. Respondent? 4, 1, and 3. In regarding 9F Securities litigation, appellant? Respondent?
6, Your Honor.
4, 3, and 6. People versus Guante, appellant? Respondent? 6, 1, and 6. Vejuno versus MTA, appellant? Respondent?
6, please.
5, 1, and 5. Yakti Properties versus Milner, appellant? Respondent? 3, 2, and 3. People versus Negroni is submitted. GNY Maintenance versus Core Continental is submitted. Cassiano versus RG Ortiz Funeral is submitted. And the first case is People versus Rivas.
May it please the Court. The Center for Appellate Litigation by Sarah Siegel. Your Honors, the record here is silent regarding Luis Rivas' constitutional rights, except for its proof that he had not received the benefit of any advice from counsel about the plea that he was supposed to take.
Well, let me ask you something, because even if we agree with all of you, I want to go straight to the relief you're requesting, which is not to remand it for resentencing, but to dismiss. But typically, even if we agreed with you, the normal remedy that we would give is to remand for resentencing. So why would we dismiss rather than remand for sentencing, if we agree with you?
Thank you, Justice Kern. First, it's the only practicable remedy here. Luis already has been deported. He cannot appear for further proceedings, and it would simply burden the lower
Would you
court.
agree that in general,
the remedy you seek is for relatively minor crimes, and here this is a Rob 2, correct?
It is an attempted Rob 2 plea where the facts are that my client, according to the criminal complaint, approached the complainant from behind as she sat on a bench, pulled her ponytail, placed his arm around her neck, and took the phone from her hand.
Right, so would you characterize that as a violent crime?
I would
Just
not.
from the perspective of the victim, who's sitting on the bench and getting grabbed by the neck.
Certainly, it requires force, Your Honor. That's an element.
So is it the minor kind of crime that we should grant the relief you seek?
I would point to several factors in response to Your Honor's question. First, it is that Luis himself, first it's the fact that there's no physical harm here. There's no weapon. And the fact that it's a Rob 2, it's indicted as a Rob 2 because of an unapprehended other by whom he was aided. That's the section of Rob 2 under which this was indicted. And we don't know anything about this unapprehended other. According to the criminal complaint, we just know that he was male. But it's elevated to felony status. This could have been charged in many instances as a misdemeanor. In trial practice, I have seen such cases charged as misdemeanors. But this was elevated to a felony because of an unapprehended other. So we don't know much about him, but we do know that around this time, Luis, who was a horrifically traumatized young man, 17 at the time of this offense, was being trafficked, was being raped by an older man in exchange for food, which he needed because he was in truly desperate circumstances that are detailed in the brief and that I won't belabor here, but I'm certainly happy to answer the court's questions regarding. He was also severely mentally ill. In fact, the lower court received a notice from Rikers itself that Rikers clinicians believe that this young man might require civil commitment. Under those circumstances, this conduct, while not something that I would excuse or minimize, compared against the standard of relatively minor, not a minor crime, but the language is relatively minor. Your Honors certainly have see every day Rob 2s that are much more serious than this, that involve much more blatant violence, that actually involve physical harm, any allegation of physical harm, which is completely absent here, that involve weapons, no weapons involved here, and where there's no specter of an older man trafficking this young man, which, by the way, would not have been the first time that he had been trafficked, having been trafficked across the border by the Sinaloa cartel at gunpoint to carry a backpack, and then being detained by ICE, which beat him to the point of permanent hearing loss in one ear and permitted him to hang himself with his bed sheets while in custody. The other important question here is that there's no windfall. There's no windfall at all. So normally, the purpose of a remand would be to see what would happen with this case. And the purpose of a conviction, were it to be obtained anew, would be, one, the ability to impose sentence, and sentence already has been imposed and already has been served in full. The second purpose of a remand might be to see if we could make this conviction a permanent stain on Luis's life, to see if we wish the permanent opprobrium and future disability of a criminal conviction to apply to this young man who was, as I said, 17 at the time of the offense. While raise the age legislation took effect 6 months too late for this young man to benefit, were this to be prosecuted today, having been committed today, it almost certainly would have been removed to family court. And there would be nothing because of the public policy as articulated by the legislature of this state that crimes committed under the age of 18 should not have those permanent consequences, which are the only ones that really could result here that have not already been meted out to Luis. Your Honors, respectfully, we submit that dismissal is both the just remedy here and the only practicable one. I'll reserve the rest of my time unless the court has other questions.
Thank you.
Good afternoon, Your Honors. May it please the Court. Nathan Morganti on behalf of the people. The totality of the record shows the defendant's plea was made voluntarily, intelligently, and knowingly, but regardless, defendant's request for dismissal is improper, and this court can decide on that alone.
What about your adversary's point that given his age, law changes subsequently, that we should take that into consideration in deciding whether or not to grant the relief sought?
Well, Your Honor, my first response to that is I don't believe that that's a factor in the improper remedy analysis. The improper remedy analysis is Is this a not serious crime, and do the people consent? And that's kind of outside what this court should be
What
looking
about her argument that it really isn't that serious a crime under the circumstances?
Your Honor, I think this is a very serious crime. When we look at the facts as put out in the complaint, a woman was sitting on a bench. One man comes up in front of her. Defendant comes up behind her, takes his arm and places it around her neck. While his arm is around her neck, he then pulls on her ponytail, and then at some point during that process uses one of those hands to rip the phone out of her hands and run away. That is serious. It's defined as a violent felony for sentencing purposes, and indeed, he had to use force to do this, both the force of pulling, for force 3 times, putting his hand around her neck to restrain her, his arm around her neck to restrain her, using his hand to pull on her ponytail, and then using force to remove the phone from her hand. That is a serious offense, and that should be taken into, and that's the
Well,
most.
when you say serious, is it a violent offense?
It is a violent offense too, Your Honor. And even though an offense does not need to be violent to be serious, I think in this instance it is both a violent and a serious offense, as the Court of Appeals called for in Allen. And that's the rule from the Court of Appeals, that it is proper when it's only minor, as Your Honors have when it is a minor offense, as Your Honors have pointed out. And defendant can point to no case law that undercuts this and would apply dismissal to this violent, serious offense. And indeed, just like in Allen, where the Court of Appeals ordered remand, here defendant committed a serious violent crime. Nor can defendant point to any case law that creates a practicability exception, which is really what defendant is arguing for here. There's nothing in the case law, there's nothing in the CPL that says there's a practicability exception when a defendant can't be brought back. And just to turn to the windfall question that my adversary brought up, there is a windfall here. The windfall would be the defendant would not have this felony conviction. And the penological purpose here is not just the sentence the defendant received here, the very beneficial sentence to him they received, where he received no jail time, but the windfall of removing that felony conviction. That is still a windfall. That is still a very serious thing, and defendant should not be granted that windfall because of the relief that he has requested is improper. If Your Honors have no further questions, we ask that you affirm.
Thank you.
Thank you.
Unless the court has questions, I waive any further response.
Thank you.
Thank you.
Are there any questions? Thank you.
Thank you very much.
Brook versus Solsman.
Good afternoon, Your Honors.
Good afternoon.
May it please the court. My name is Dan Isaacs. I represent the estate of Judith Brook, and we appealed from an order of the Supreme Court issued on February 14th of 2024, awarding in advance $75,000 in attorney's fees, which were characterized as administrative expenses that were to be paid by the estate.
Well, first, would you agree that attorney's fees, putting aside the issues with respect to statute, can attorney's fees be considered administrative expenses?
Yes, Your Honor, but not under these circumstances. Clearly, I mean, to begin with, my client, Judith Brook, died on March 15th of 2020. The court issued nearly 6 months before awarding these attorney's fees, settled the accounting. Under the statute,
The counsel, weren't the attorney's fees at issue in this case were for 2 appeals that were initiated after the submission of the final, what was supposed to be the final accounting. So why would the final accounting be completed when there was still litigation going on, clearly related to the estate before the final accounting was completely settled, and while the guardian was still retaining the funds? How could that be final?
I would argue, Your Honor, that those issues had to do with the malfeasance and defalcations of the guardian, Mr. Rutolo. No court,
But
including
isn't
this
that part
court,
of what the
has-
court decide? I mean, the attorney fees are only going to be awarded if the court finds that appropriate. Isn't that part of the court's job to make a determination whether or not attorney's fees are appropriately awarded to the guardian under the particular circumstances of the case?
Well, that's part of the problem with this case, Your Honor. Again, no court has ever ruled on the merits of the underlying claims in this case with what the guardian did, either in selling millions of dollars in securities to gin up his commissions,
Well, has there ever
which
been
the lower
any,
court
counsel,
denied.
has there ever been any finding that the guardian did anything inappropriate in this case, so that was a malfeasance of
I would
duties?
argue yes, Your Honor.
What finding was there?
I would argue, yes. It would be the guardianship when, the guardian court, when Judge Kelly or Justice Kelly made an award of fees, she denied his request for commissions because she found in her ruling that he made financial decisions which negatively impact the estate, which cost
What
tens
does
of
that have to
thousands of
do,
dollars to.
what does that have to do with this particular award of counsel fees for appeals initiated by your co-defendant?
Which were
because, Your
dismissed,
Honor-
which cases were dismissed, and finding no malfeasance by the guardian, in fact.
Well, I would argue, again, she denied commissions because she
No,
found.
we're talking about the underlying cases for which the attorney's fees are being sought.
Well, Your Honor, we have a case pending in the Supreme Court that will address those allegations, but to have the estate.
So it sounds like
pay in
there'll be more
advance-
attorney's fees.
Right, but to have an estate pay in advance for attorney's fees, now it's unfortunate, and the court noted in its decision that Mr. Rotolo was not bonded. Okay, but is that our fault? He should have been bonded, particularly with handling an estate that was worth millions and millions of dollars, and he
Counsel,
wasn't.
you know, let's go back. It seems to me that there were still matters pending. And what I'm talking about is that
Your Honor.
the final account had yet to be settled. There was a lot of litigation relating to the administration of the guardianship, and I just don't understand. Please, educate me. No, I'm not done. As to why these fees are not, reasonably related to the administration of the guardianship, and also that they were reasonably anticipated because of the various challenges, because of the various litigations.
I'll say, Your Honor, that the fees are related not to the administration of the estate per se, but to defending his own actions as the guardian. And again, Your
Which, as my colleague said, there was no finding ever that there was any wrongdoing by Mr. Rotolo.
So, Your Honor, that's an outstanding question. So why should he be entitled to take $75,000 from the estate funds to defend himself? And what happens, Judge?
Because the court
Ultimately, we
found
have
that
a
it was
decision.
appropriate. That's the court's job, to make a determination when a guardian is entitled to attorney's fees. The court looked at the particular circumstances of this case and found it was appropriate.
I would say, Your Honor, I see that my time is up, but I would say that based upon the unique facts and circumstances, this was a very unique situation.
Thank you. Okay, I'll let you respond to that in
All
rebuttal.
right, thank
Why
you,
it's
Your Honor. I
unique.
appreciate your time.
It is a unique situation, I agree.
It is indeed, unfortunately, but thank you.
Unfortunately.
Good afternoon, Your Honors. May it please the court. This court is correct that the sole question before it is whether the guardianship court properly exercised its discretion in awarding $75,000 in administrative expenses.
Refresh my recollection, counsel. At the time of the various hearings before Supreme Court, for the guardianship court, was the issue of malfeasance raised in connection with the claim for attorney's fees?
Yes, Your Honor, those issues.
What occurred? What did the court do at that point?
The court held a hearing, it received submissions, it held a hearing over multiple days, and it issued an order awarding Mr. Rotolo compensation, making findings that he satisfactorily performed his duties, and that order was affirmed by this court. With respect to Mr. Isaac's claim that the court denied him commissions because it made a finding somehow that he had acted negligently with respect to the finances, a reading of that order will make clear that that is not the case. There was no finding made that he did anything improper. The court stated in its decision that it had considered the appellant's claims with respect to that. The court did not impose a surcharge, and the court did not cite any misconduct, which it did not find, as a basis for its fee award. So,
Counsel, what about the argument that it was too late? That at this point, where the final accounting had been submitted, it's too late to award additional fees?
well, essentially what appellants are arguing is that, the guardianship court did not have jurisdiction anymore, everything ended, she died, the final accounting was settled, And, the appellants have invoked not only the guardianship court's jurisdiction, but this court's jurisdiction, the jurisdiction of the state court in which they filed proceedings rehashing these same claims, and the jurisdiction of the federal courts rehashing the same claims. So they are the ones who have affirmatively attempted to litigate issues that would have, in the normal course of business, have been over when the final accounting was
But in
settled.
this instance also, the court segregated $500,000 for administrative expenses, mostly attorney's fees, which we affirmed.
Yes.
What was the reason for having the segregated funds available?
The purpose of the segregation of the funds was to cover the administrative costs and expenses of the
And
guardianship.
were those administrative costs and expenses known at the time when the final accounting was filed?
At the time, there were some known, but it was not known that these litigations that I have just discussed would be filed. When they were filed, when the guardian was aware that the appellants were continuing the litigation with the guardianship, he went back to the guardianship court, to a new judge, Judge Sokolov, to ask that the court award the
So was there ever a
$75,000.
final accounting with respect to this, with respect to administrative expenses?
There was not.
Thank you.
Thank you.
Your Honor, I just want to briefly say, and the Judge brought up a point, $500,000, $500,000 was put aside to pay fees in a guardianship that basically lasted 71 days. On January 3rd of 2020, when Mr. Rotolo obtained full powers.
Counsel, whose decision was it to continue litigating once the guardianship was wrapping up? Who made the decision to continue litigation?
The estate did, Your Honor, to
So
rectify
wasn't
wrong.
it the estate who was the cause of additional litigation and fees being generated once the accounting part of it was completed?
I would argue, Your Honor, respectfully, that the cause was the actions of Mr. Rotolo, putting my client in a nursing home without a hearing against
Counsel,
her will.
if the final accounting had not been settled yet because of these anticipated administrative costs based on this being a very litigious action, what's wrong with going to the guardianship court and requesting fees, appropriate fees?
Because, Your Honor, in this instance here, he's asking for the estate to pay to defend him against injuries and damages he caused the estate. We're paying to defend
So there's no
him for damages he
statutory
caused my client.
prohibition, right? Because the final accounting had not been settled yet.
Well, there had been an accounting that was issued on 6 months earlier in August before the fees were awarded, and the account was considered final.
Thank you. Thank
no
you very
shot.
much.
All right, thank you all for your time.
Alpert versus Monan.
Good afternoon. May it please the court, Sim Shapiro from the law firm of Strykowski, Drachman, and Shapiro for the appellants. In this case, in order to establish their entitlement to summary judgment, the plaintiffs would have needed to show negligence, not just evidence of negligence, but negligence, and that such negligence was the proximate cause of the plaintiff's injuries. And I submit in this case, they actually did not meet their burden to establish either one of those. Again, they would have had to establish
Here
both.
the plaintiff alleges that when he tripped, he reached for a railing and there was nothing there and he fell. So there's that one fact. There's an allegation of inadequate lighting, and there's also an assertion, which you say are different kinds of cases, that there have been prior faults. So taking it all together with all those facts, is that sufficient to make a finding of negligence in this case?
It is not. It is sufficient for an attorney to...
What else more would you need?
I think that's sufficient for an attorney to argue to a jury, but I do want to point out that the court below did not grant summary judgment on the basis of lighting. It was limited specifically to the handrail issue.
But the court noted all the other circumstances. It wasn't just the absence of the handrail that was the reason the court granted summary judgment. Let me ask you,
That actually is the reason the court granted summary judgment, and the court was specific in limiting it that.
The evidence is in the record about the lack of lighting, the prior accidents, et cetera. What did your client raise as an issue of fact in opposition to the showing made by plaintiff in this case that he was entitled to summary judgment? What was a factual issue you identified?
Well, specifically, although again, the court did not base its decision at all on the lighting, there was an expert who opined that the lighting was
So that
completely
evidence
proper.
is in the record, and it's proper for us to consider.
It's in the record. If the point is the court is making a search of the record to grant summary judgment on a basis the court below didn't, I would respectfully submit that the issue for the appeal here anyway is, because that really wasn't briefed, because it wasn't an argument that was made, because it wasn't a basis for summary judgment.
But can you answer the question I asked, which is what is the issue of fact you're identifying that would make summary judgment inappropriate under the circumstances of this?
With regard to the lighting, there's an expert.
Not just the lighting.
Okay. With regard to the totality.
Everything, the totality of the circumstances, what are you identifying as the issue of fact that prevents summary judgment from being granted?
Again, I think that you need to looking at the issues.
I
We're looking at them
understand your
together,
other
but there's
argument.
an expert who says.
Your argument is that it's not before us. I understand that's your argument, but assuming that we are going to look at the totality of the circumstances in deciding this appeal, then what is the issue of fact?
Even looking at the totality, there's an expert on behalf of defendants, there's an affidavit from an expert saying that the lighting was appropriate. That's ultimately for a jury to decide. Looking at the handrail issue, again, there's evidence of negligence. Their expert they never met their burden because their expert didn't say this was the cause or a cause.
So that's your argument, right? That's really your argument. You're saying that you don't have to raise an issue of fact because the movement did not establish a prima facie case. That's what you're
correct
really
with regard to the handrail issue. I'll go beyond that because it was, in fact, obviously there were arguments made in opposition that, in fact, they hadn't established
Out of
proximate
curiosity,
cause.
what more can plaintiffs say to make out a prima facie case here, other than saying you violated the administrative code, there have been prior accidents, the lighting may be inadequate. What more is there to make out a prima facie? And you get an expert affidavit.
Well, they can make out a prima facie case with regard to the lighting, but there was an issue of fact because of the expert. To the extent
What
that
was that issue of fact?
there's an expert's affidavit saying that they view the lighting as appropriate. Now, if the
I just want to go back because obviously there was a violation regarding the handrail. That's not in dispute. And then there was the plaintiff's expert that indicated there was a proper handrail that would have, stopped the fall. So how was there an issue that overcame that? Can you address that?
Well, two pieces to that. First of all, the expert said it would have lessened the severity
Okay,
of the
well,
injury.
I'm-
So
you
that's
know.
that's not the same as saying that the accident wouldn't have happened. That's saying it wouldn't have been as severe. Of course, he doesn't say exactly how severe, and it's not clear how does a jury determine that.
But just the plaintiff's testimony was that he was walking down a dark staircase. He lost his balance, reached to the left for a handrail, no handrail there, and falls down.
Actually, what he says, and remember, I think it's very important to note, he's walking holding the hand of his wife, who is holding onto the handrail. So he's actually very much in a position to hold onto the handrail. What he said is, I reached forward, and it's really not clear what he's saying because he didn't say I reached to the side. He reached forward, and obviously that wouldn't have worked out in terms of grabbing for the handrail. There's a handrail right there. He could have walked next to it. There's no indication to the extent that the claim here is that, look, there's a violation because you need to have more handrails, that having more handrails when he's obviously very much adjacent to one.
So isn't it undisputed that there was a violation of the administrative code in terms of the handrails? Is there any dispute about that?
There is no dispute in the court below. That's still evidence of negligence, and that still has to be the cause or
And
a cause.
Isn't that plaintiff's testimony that he fell, he believes, because there was nothing to grab onto when he fell?
That was not his testimony.
He didn't testify there
His
was nothing to
testimony
grab
was
onto?
his testimony. He reached ahead of him. So that's
He
not
didn't reach to the left.
I'm sorry.
He did not reach to the
He
left.
said he couldn't reach ahead. He said he believed he was holding his wife's hand at the time.
Okay, you'll have time to rebuttal. Thank you.
Good afternoon, Your Honors. Arnold D. Joseph for the plaintiff respondent.
Good afternoon. If you can go back, maybe you can answer my question because he didn't answer it, with respect to was there any issue shown with respect to your expert, that the fall could have been completed, you know what he said, with the proper handrails.
There's no evidence in this case submitted by the defendant that the lack of a handrail was not a proximate cause of
Well,
this.
what are the facts? Did he reach to the left or did he reach to the front?
He says, judges, that the pages at 210 and 211 of the record is the 2 pages regarding what Dr. Albert did at the time of the fall. And I believe on page 210, he says he reached ahead to grab onto something, but there was no railing to grab onto. And I think he says again, I reached to grab, but there was nothing to grab onto. Now, let's get something straight. The issue of comparative fault is still alive. So when the defendant comes here and says, well, he could have been walking next to the railing behind his wife, he could have been doing this, yes. And there's going to be a trial about that, because the only thing the court below did is said, wait a minute, you come in, you orally argue the motion, you admit on the record that you violated the code.
But your adversary is correct that violation of a regulation is some evidence of negligence. So they're saying you didn't make out your prima facie.
Right.
How did you make out your
They're
prima facie?
saying we didn't make out the prima facie on proximate cause. That's the only basis of this appeal. Like, it can't be any other. And the point is you heard it out of the defendant's position. The proximate cause. He kept saying the proximate cause. Wasn't until the end of his argument, even today, that he finally said
Well, he did say A.
a
I heard
proximate
A.
cause. Yes, at the end of his argument, he finally said a proximate cause. And the point is, every lack of a hand railing case, this is what happens. The person goes to reach for the handrail. There's no handrail. And he falls, and he would have said, if I had a handrail, yes, it's a reasonable inference. It's foreseeable. If there's no handrail where it's supposed to be, and someone loses their balance and starts to fall, and they reach out, that's a proximate cause of the fall as well as whether or not the lighting is involved.
What about the prior accidents?
And the prior accidents in this instance, Judge, they are something the court can consider, but I very rarely have in any case where the defendant's counsel admits on the record that they violated the building code. Yes, you're correct, they violated the building code. We didn't have a handrail where it was supposed to. The plaintiff testified when he started to fall, he reached for a handrail that didn't exist. Issue of comparative fault as to where he was walking, because there was a handrail he could have used, is alive and well for the jury. And I think the court below got this 100% right. Did I answer your question, Judge?
You did, thank you.
Thank you.
Thank you.
Thank you.
Good afternoon again. So first of all, my honored colleague is not correct in saying that the only argument we're making is proximate cause. In fact, I should point out that even in the court below, the attorney for the plaintiff at oral argument said, look, the issue with regard to the lighting is negligence per se, but they were saying that the evidence, that was just evidence of negligence with regard to the handrails. That's on page 15 or 16, page 14 to 15 of the record. So that's not actually correct, because even they said to the court below that it's simply evidence of negligence, not negligence per se, which is of course correct. So the issue here is one of, if we're talking about lighting, well, look, there's an issue of fact because it's battling experts. If we're talking about the issue with the handrails, they even acknowledge that they haven't met their burden on that before we ever get to proximate cause. Now, I'm sorry, Your Honor, Justice Kennedy, it sounded like I had not answered your question.
But I got it answered,
Okay.
it's fine.
Okay, I'm happy to answer it again if you'll reiterate that question.
No, I'm good.
Okay. So that said, if in fact you would get to proximate cause, yes, as counsel acknowledged, the plaintiff himself said he reached ahead and there was nothing there.
Thank you.
Thank you.
Wano versus City of New York.
Good afternoon, Your Honors. May it please the Court, Jonathan Popolo for appellants. The Workers' Compensation Board's determination is dispositive of this appeal. Plaintiff's sole and exclusive remedy is workers' compensation as a matter of law. Supreme Court erroneously held that summary judgment was premature because no depositions have been taken yet, but depositions can't change the Workers' Compensation Board's determination or the exclusivity provisions of the Workers' Compensation Law.
Your argument is once the workers' comp made their determination, that the plaintiff was an employee, that was the end of the analysis, then
Correct,
exclusivity.
correct, and
becomes
that can't change during
Did
depositions.
the plaintiff receive any insurance, workers' comp benefits?
Plaintiff there was unrefuted evidence of payment of medical expenses,
About
which
$10,000, correct?
10,000, yeah. I think certainly there was $6,000 that were on the first motion that were supported by an affidavit, and I think there was some further documentary evidence on the second motion of an additional 4,000. And plaintiff doesn't actually dispute that those, she says she's unaware of payments to her providers, but she doesn't actually dispute that those were paid. And we had evidence from the, in the first motion supported by an affidavit and documentary evidence of those payments. And the only other piece is there was a determination of an average weekly wage, but the court, I think the Supreme Court unfortunately somewhat, I don't think intentionally obviously, but mischaracterized that decision. It wasn't an award, it was a setting of that, and the Workers' Compensation Board went on, and this is at page 201 of the record, to say, I further find that as claimant has provided no proof of any earnings in covered employment and no evidence of attachment to the labor market, there was no expectation of wages after August 4th, 2018. That was the date of the car crash. And the claimant is not entitled to any award for lost time. And so if they have any issue with that, it doesn't,
That's not the issue before us, though, whether.
correct. She has to take that up with the Workers' Compensation Board. Yeah,
Thank you.
thanks.
Good afternoon, Your Honors. May it please the court, Jack Lockwood for the plaintiff respondent.
Counsel, didn't your client file the workers' comp claim?
That's correct, Your Honor. She filed a work.
And didn't the workers' board find that she was entitled to benefits, and in fact, didn't she receive benefits?
I don't think it's quite so clear as that, Your Honor. The first
She didn't receive any medical reimbursements or?
her affidavit, she claims that she did not receive any. She's not aware of
Does
it.
she have to, I'm sorry.
Go ahead.
Does she have to have received it? There was a determination that she was entitled to workers' compensation.
Well, there is a question. City argues that once I think they cite to the Court of Appeals case in Liss where they latch onto the word, and once you're entitled to it. There's a lot of other case law out there that says once you actually receive it. So to the extent that you have to receive it, there's a question.
To be clear, she went to the Workers' Compensation Board as a worker to receive benefits, correct?
She went there after her no fault. She went to the no fault. She tried to apply under the no fault law, first of all, because this was a car accident case. She was denied no fault benefits because she was in this work experience program. She was a street food vendor that was doing community service because she had gotten a ticket.
We understand the facts, but there's no dispute in this case that she went to the Workers' Comp Board and argued she was an employee, because that's why you go to the Workers' Comp Board, and the Workers' Comp Board made a determination that she was an employee.
The Workers' Comp Board made it, the first determination found an employer-employee relationship.
Once
and then the
that
second,
determination is made, how could, isn't that black letter law that the exclusivity provisions come into play?
Your Honor, the second determination undermines the finding in the first determination. As my colleague pointed out, actually, it set an average weekly wage and then determined that she was not entitled to any back
Whether
pay.
or not she got wages or not, how does that alter the fact that a determination was made that she was an employee, which would thereby trigger the exclusivity?
The definition of employee, and I think it's in Workers' Comp Section 2, is engaged in covered activity, the covered employment.
She was deemed to be that, just not entitled to certain payments.
Not in the second workers' compensation determination. She was no proof of that she was in covered employment.
Well, then, if you're saying there's an inconsistency between the two findings, isn't it that your remedy really is to appeal the second finding?
That may be, Your Honor, and under 123, workers' comp still has continuing jurisdiction for a number of years. This is a motion for summary judgment. It was denied with leave to renew after more discovery takes place. This is also a very unusual situation. This isn't a normal workers' compensation. I see
Thank
my
you.
time's up.
Thank you.
Thank you, Your Honor.
Your Honors, if you have specific questions, I'm certainly
Yeah,
happy to answer.
your adversary seems to be disputing the receipt of $6,000 or $10,000. Can you address that?
Sure. First of all, don't directly dispute it. She said she wasn't aware of her providers receiving it, because that was money that's being paid directly to providers for her medical
She wouldn't be
costs.
receiving it. These are
She would not be receiving it, correct. And she doesn't directly refute it. She doesn't say, I've gotten the bill. She doesn't say the providers called me up and said I haven't been paid. She says, I'm not aware. And that's not enough to create a material issue of fact.
And if if providers aren't paid and they're required to be paid, what's the remedy?
The remedy then is further proceedings before the Workers'
What
Compensation
about
Board.
her argument that the second determination essentially determined that she was not entitled to be deemed a worker?
No, it didn't determine that. It determined that she wasn't necessarily entitled to wage replacement because she hadn't established what her wage was in other work or things like that. It definitely did not say she wasn't an employee.
Does that last determination require more discovery?
No, absolutely not, Your Honor, because you're not automatically entitled to, they set what the average weekly wage might be, but you're not automatically entitled to that then. I think there are further proceedings that you have to bring. There are things you have to show under the workers' compensation law.
So she was deemed a worker. What's outstanding really is how much wages she should be entitled to, if any.
Correct, and the determination of that doesn't vitiate the exclusivity provisions of the workers' compensation law. Thank you.
Thank you. Sanchez versus Bronx United.
Good afternoon, Your Honors. Jillian Rosen for the Plaintiff Appellant. In this case, it's our position, this is a burden-shifting paradigm case, in our opinion. And the defendant didn't establish prima facie that they neither created nor had notice of the leak in the bathroom. We know—
How is this burden shifting if this is something that is evident within her bathroom, right, that she would have information about, not anyone else? How is that burden shifting?
Because what we know is on January 8th, they allegedly repaired the leak from the same area that she then claims had black spots and that
But the accident or the alleged accident didn't happen until many days later after they had already gone back and looked at the area.
Right, and our allegation is that there's no evidence that it was repaired, whether it was repaired properly or
Didn't she
completed.
testify that there wasn't any, she didn't see any water on the day of the accident? Before the accident, she didn't see any water or didn't make any complaints to the building that there was recurring water after that incident. She didn't make any comment after the repair had taken place.
Correct, between the 8th and the 18th she didn't, but if you look at the photographs of these black spots on the wall that were present, and that she said when
How is that evidence that there was an ongoing water on the floor that caused her to fall?
Well, what her testimony is, and her testimony is difficult to follow, is that when they came on the 8th, that if you look at the photographs, it's between the toilet and the vanity, and there's like a pipe that's kind of exposed, and that's as a result of the first pipe leak. And they said that they came and they put their hands in and they made it worse. That's her testimony. If you look at the photographs, you can see the black in the back. She did say, and also—
She complained to the building after the alleged repair happened that the situation was made worse?
She didn't complain. She did not complain. But we have a situation where there's a duty on the building, as the law is a duty on the building to inspect, and there was no inspection put in place. So there was no inspection. We don't know what was done on the 8th. If you look at all we have is an invoice.
This is not like a public space where you have to go mop the stairway or mop the public supermarket. It's not that type of case. It's her bathroom. They have to be put on some notice that there's a problem before they can go in and do something. And the evidence appears to be that when she did report a problem, they did promptly go in and send someone in to repair it. And then there's no record in the evidence of any further complaints. So how could they have known that there was something else that needed to be taken care of.
Because our position is that we don't know, I mean, you just said they went in and they repaired it on the 8th, but if you look at 321 of the record and 320, we have no evidence as what was done. We don't know anything that was done, we don't know what was done on the 8th. They say they did it, but there's no Bruckner job
Was there a
sheet.
leak on the 9th? Did your client complain of a leak on the 9th?
No, she did not complain of anything.
Leak on the 10th?
No, except
Leak
that,
on the 17th?
no,
It was the 18th when there was water on the floor. So
correct.
how does that establish notice?
Well, our position is let's take Bruckner for
You're
a
saying
second.
they caused the condition? Is that what you're arguing?
For Bruckner, I'd have to obviously do Espinal with launching an instrument of harm. But if you look at Bruckner, I think there's an issue of fact for Bruckner as to whether they caused and created from the very fact, and this is why I said burden shifting, is that we don't know what they did on the 8th and whether it was done properly because it's only 9 days
She
later.
didn't complain of anything between when the repair was done and when the accident occurred.
Correct, Your Honor. But if it's a cause and create situation, then notice becomes irrelevant.
Thank you.
Uh,
You have
Okay,
time
I'll
to
take it
rebut.
up on reply. Thank you.
Good afternoon. May it please the court. My name is Hillary Simon from Kennedy's, and I represent respondents.
Your adversary is arguing that Buckner was the instrumentality of the harm because they were negligent in repairing the leak on the 8th. How did you establish that all the work was done properly, et cetera?
Sure. We called them immediately after 9 days prior to the incident for them to come and repair the leak. Bruckner is, we use them regularly for plumbing repairs. And then after that happened, the plaintiff made no complaint. She said that there was a leak there. And then after that occurred, there was no water. She herself testified that on the day before the incident, that she didn't see any water on the floor and that she had just seen a little bit of water after. And she testified about having prior issues with her shower curtain in the bathtub. She admitted to bathing.
And counsel, if I may, after the accident, there was a repairman who went back to check, and there was no leak, and actually indicated that it appeared that there was a lack of a waterproof shower curtain that probably, spilled the water on the floor.
Yeah, we called Bruckner immediately after her reporting that she fell, and they came back immediately afterwards. They checked everything and talked to plaintiff, and they made the determination that there was no issues with the plumbing. They didn't have to do any repairs. They haven't had to do any repairs in her apartment since then, and that she hadn't had a plastic shower curtain there, so the water was leaking from the mesh curtain. And plaintiff herself admitted she didn't know where the water came from, and so that could have easily been caused by a shower curtain, wasn't caused by the plumbing issues. And plaintiff hasn't proven that Bronx United or Daugert had any notice of the condition. It was at 10 p.m. in her private bathroom, and we wouldn't have known that there was any issues because she didn't complain in those 9 days.
Does the law impose a duty on the owner to inspect pipes behind walls, et cetera?
It does, but in this case, we fulfilled that duty because plaintiff complained of that her bathroom was leaking, and we immediately had it repaired. And then we wouldn't have known that there was any further issues until it's her private apartment, until she made further complaints, which she did.
What about the black spots that they allege were there by the pipe?
There's no evidence that there were black spots there, and regardless, it's not a cause of the incident happening. Thank you, Your Honors.
Thank you.
May it please the court. My name is Catherine Gaffaro from Bryan Wright Hill, and I represent Bruckner, who was the third-party contractor that came to the plaintiff's apartment on the 8th to fix a leak. And despite plaintiff's contentions, there were invoices, and a person from my company came and gave testimony to these invoices that said exactly what Bruckner did, which included repairing a pipe that my my employee named Jose actually came and said that there was actually a leak. Then he left with no leak. More than a week goes by, we receive another phone call from the owner to come back. We go back, Mr. Mitchell goes, he checks everything. He details everything that he checked. He even sprays all of the shower walls to find a leak. He then shows the plaintiff, you have a mesh curtain. He takes the water hose. He shows her, if you shower with a mesh curtain, the water's gonna get on the floor. She admits to this. She admits she should have dried it. More importantly, her girlfriend had taken a shower sometime prior to this fall. Okay, and in order for a third-party contractors, myself, to be liable, obviously we don't own a duty because we don't own the premises. We have no duty to inspect. We don't occupy, we don't control, we don't maintain. She has to prove that we launched a harm. She can't prove that. There were no complaints about any
What
further
she's
leak.
saying is that the burden is being impermissibly shifted to her. Do you assert that all of what you've just stated establishes that you've met your burden, that you did not launch an instrument of harm?
I believe we did not. We did not launch because it is their burden. She has to prove those exceptions to hold me as a third-party contractor in, and she has not. There are 0 complaints of a leak, and it's very important that after we came back, we still made no additional repairs because there were no leaks. And more importantly, the mold are photographs that she couldn't even, there's no metadata to them. We don't even know when they were taken, and she just admitted they were from the first leak, which we fixed. And then she has to show that we caused and created an issue or made it worse. Again, there was no water. She testified she used that bathroom 6 or 7 times that day. There was no water on the floor. And even after she fell, it wasn't until after she fell that she noticed it was damp, and specifically said it was very little water. They have come forth with no conflicting testimony that there was no leak. There's no expert here to say, wait, this was not repaired correctly. There's no complaints that it wasn't repaired correctly, and more importantly, there's no physical evidence that we didn't repair it correctly. And so we feel that the lower court's decision should be affirmed.
Thank you.
Thank you.
Judge Singh asked if a plaintiff has an obligation to inspect pipes. No, it's not. I mean, obviously the law is that we're.
I meant the owner, I think.
No, the owner, right, of course. No, I understand that. I'm just saying the.
Well, she conceded that the owner had.
Yes, right. To your point, the owner has a duty, and our position is that.
Even if they have that duty, how was it breached here? What your adversary argued was your client complains of a leak, Buckner's called, leak is fixed. What more can they do?
There were no complaints after that, after the leak is fixed.
We think the leak is fixed. My point.
But there were no complaints after that.
I know that, but she's a resident, and she doesn't know if the leak was fixed or not. She knows that 9 days later.
Then you get an expert. You get an expert to go and inspect the premises. I recognize that it's difficult now that so much time's gone by, but that's how it's done in other cases, right? To show that, in fact, Buckner's fix was inappropriate.
Right. Well, interestingly about Mitchell, and 2 things. One is that she didn't use the bathroom right before. She used the bathroom 2 hours before, and there was no water. So, and Mitchell comes on the 18th, and he's not in a position to see if the repair had been done properly because he didn't even know that Jose was there 8 days ago.
Thank you.
So,
Thank you.
okay, thank you.
Sorz versus Rahmatullayev.
If I may, Your Honor, Jacob Tabor for respondent pursuant to the pro hoc letter requesting permission from myself.
Thank you. It's granted.
Good afternoon, Your Honor. Jason Firestein for the appellant Nicole Sorz. Uber charted a very specific course when it made a motion for summary judgment based solely on the affidavit of Todd Gaddis and the limited piece of data from the driver, Rahmatullayev, for the morning of the accident. Notwithstanding that during discovery, a whole lot of other information was available, and notwithstanding that Mr. Rahmatullayev himself provided testimony prior to the motion. The affidavit, supported by Gaddis, only focuses on one issue, the Uber app status, the alleged Uber app status at the moment of the accident with the pedestrian. And it's Uber's claim that at some point in time, approximately 5 to 6 minutes before the accident, that the driver logged off of the Uber app. Now, that's not based upon anything that the driver said. It's certainly not based on any evidence that they put
Well,
forth.
let's assume that the driver testified that he logged off the app. Is that in itself sufficient to say that Uber, as a matter of law, can't be found to be the employer?
Absolutely, you're absolutely correct. They can,
And why-
standing
That's not a
alone.
question. You can't tell him he's absolutely correct. He's asking you.
It's a softball, but
Yeah, no, standing alone, that is not the only analysis that the court must perform. That's certainly not the analysis that.
So why is there an issue of fact that, as to whether or not he was acting within the scope of his employment when the accident occurred? What's the evidence that creates an issue of fact?
Well, it's the initial burden of Uber, of course, to come fact, and the mere fact that.
Yeah, but their initial burden is that the app was off at the time the accident occurred. So what's your response to that, why that is not conclusive?
That's not conclusive for a number of reasons. So the first reason is the only person who states that the app is off is the Uber employee, Gaddis. There's a presumption in that affidavit that it's the volitional act of the driver to log off. When you look at when the driver's testimony is available, which it certainly was when Uber could have made its summary judgment motion, he certainly had no idea that the app was
I'm
off.
sorry, is your argument that if the app was off, they win? Is that the argument you're making?
No, it's the opposite.
It sounds like you're saying that if the app was off and the corrector was off, they win.
No,
Because you're arguing that there's an issue of fact as to whether the app was off, but aren't you making a broader argument?
No. The argument I'm making, Your Honor, Justice Kern, is that the concept that the driver is the person who turned the app off, standing alone, that's not the issue here. You have to look at the totality of the circumstances that the driver of.
So what are the totality of the circumstances here sufficient to raise an issue of fact?
That the driver left his home in Brooklyn at 5 o'clock in the morning, turned on the Uber application when he entered into his car.
Was he going to drive for anybody else but Uber that day? Was he, for example, going to drive for Lyft that day?
So in the record on appeal, Mr. Rahmatullayev testified on page 285 that he had no other employment. His intent was to work for Uber for 4 to 5 hours and do no other work.
Did he turn the Uber, is there evidence in the record that he turned the Uber app on again after this accident occurred?
And as a matter of fact, there is. In the Uber data that was
So does
provided.
that create an issue of fact that he was still working for Uber at the time of the accident?
Well, of course it does. On page 459 and page 462 on the record of appeal, we have the data that was provided during discovery, which you can markedly contrast with the data that was used in the summary judgment motion. You also have plaintiff's statement of material facts, where we had Uber, who did not dispute this, that the driver turned on his app that morning. He had at least one fare prior to the accident, and after the accident, he had an additional fare that he took up. That is undisputed from Uber's own data. In making their motion for summary judgment, rather than relying on the totality of the data, they give us this little tiny snippet, this little piece of time that says, well, 5 minutes before the thing goes off, and at some point in time it goes on thereafter. There's absolutely nothing when you have a burden to move for summary judgment. And the elephant in the room in terms of vicarious liability is not in front of us here today. It's presumed for purposes of this motion that you cannot simply look at a driver who may have inadvertently logged off the app or even taken a temporary break. The courts have always analyzed cases where people are driving vehicles for work, that breaks during the day, whether it's a break to use the bathroom or a break because you're tired for a moment or a break so you can answer a phone call, does not disengage you from employment.
And at best, this was a break, you're saying? Even
The
if
driver
Uber app was
himself.
off, it was a break. Well, he was looking for another fare.
Right, the driver, his testimony is conflicted. At one point in time, though, he specifically testified that I pulled over to wait for fares. You know, the beauty of the application, right, is you don't have to drive around looking for people. You can sit in a spot and the people come to you. And he testified specifically on pages 428 and 429 that he leaves the app on all the time except when he takes breaks. And he testified specifically that when he was parking, when he struck my client, his intention was to park and wait for fares. He used the the driver application beforehand. He used it up until, at the very least, minutes before the accident. And the one point about turning it off is there's this presumption that he's turning it off as to disengage himself from employment. But we don't know that. Mr. Rahmatullayev doesn't know that.
Thank you. You have time, Riva.
Thank you.
May it please the court, I'm Michael Houston of Perkins Coie on behalf of Uber. The Court of Appeals decision in Lundberg controls the scope of employment issue here. Lundberg held that the way to determine scope of employment is to ask, quote, at the time of the accident, is the worker, quote, under the control, directly or indirectly, of the employer?
In other words, a driver can be driving for 12 hours and the accident happens when the app is off. You say as a matter of law, he's not your employee, that there's no liability. Is there a case that supports that?
I think Lundberg is the best case that supports
it. Is it about an app? Is it about,
of course,
okay,
it's not about
so then let's go to the Second Department case and discuss the Second Department case. The Second Department is really clear that the mere fact that the driver turns the app on and off is not controlling.
So I think that's the Cui case from the Second Department turned principally on a dispute of fact about the affidavit of the driver and its translation, you know, because the worker didn't speak English. You're right that in the...
Well, I'm reading from the decision, contrary to Uber's contention, the averments of Hussein, et cetera, that Hussein was logged off, is simply insufficient without more to eliminate all questions of fact whether the driver was acting within scope.
Understood, Your Honor.
So why is that any different than this case? And actually, this case it's much closer.
So the reason why it's different is because, again, there was a dispute of fact in the case about what was actually going on. There is absolutely no dispute in here what the facts are. More importantly, though...
Counsel, assuming there's no dispute that the app was turned off,
yes.
What about the case law that says a driver for hire, the fact that they're taking a break for a moment is not a basis for there not being vicarious liability, since there's no dispute, or there's clearly an issue of fact as to whether he was picking up fares before the accident and picking up fares after the accident. Isn't there clearly at least a disputed issue of fact as to whether he was just taking a break at that point or waiting for another fare?
No, Your Honor, there's not any dispute. I want to answer your question in two parts, if I might. There is absolutely no dispute of fact. All of the parties agree in the record evidence about what the facts are. When he was online, when he was offline, when the accident occurred.
Right, but you're saying to say that you have to assume that being offline is dispositive. They stopped working for Uber when he went offline, and then 5 minutes later, when he went back online, he was working for
Understood.
Uber.
And my point about...
Is that how the law looks at this?
Yes, it is. And here's why. Here's why. That's a legal question. It's not a factual question. It's a legal question. And Lundberg says the way
Isn't the legal question whether he was working within the scope of employment at that time? And don't you have to look at the facts to determine that question?
You have to look at the facts, but you have to look at the facts to determine, as the Court of Appeals tells us, whether Uber had control over him. I did not hear one word from my friend at the podium about the control that Uber has. And in the We decision in the Second Department, I think that's the fundamental flaw.
He turns off the app because he's going to stop and go to the bathroom somewhere, but he plans to work many more hours during the day, then you're off the hook. There's no, while he goes to the bathroom, it terminates, and then it turns back on again when he comes back from the bathroom?
Yes, I think that's exactly right, because...
Is there a case that supports that position?
Absolutely.
Don't tell me the Court of Appeals case again, because that has nothing to do with an app.
Your Honor.
The case that you're arguing, what's the case that supports the position?
We've cited about more than 50 cases in our brief that deal with similar situations, some of which also involve drivers who had only been off the app for a few minutes. There is appellate precedent from the California court. The recent Kim decision just decided a couple months ago, similar situation. So yes, courts around the country have looked at this. Most courts haven't even thought it's a close
Doesn't that go against common sense, to be honest? Isn't it just common sense that if he went back on and took more fares after the time of this accident, that he was still working for Uber during that day and that he had not stopped working?
And he did that throughout the day. The data reflects that he was on the app and off the app multiple times during the morning.
That's absolutely right, Your Honor. And I think the common sense proposition is also the one that's reflected in the insurance regulations of this state. The legislature says when you're a TNC, when the driver is, quote, logged into the app, that's when insurance coverage is required, but not when the person is not logged into the app. So I think the insurance system that the legislature has looked at has said, we want to draw exactly that common sense distinction.
So
And
we
the
should
reason-
throw out all our common law just out the
No,
window?
no, of course not, Your Honor.
Well, because in my view, it's a question of control. And so, for example, the driver testified that he goes offline because he wants to go in the surge area, and then he can turn on to make higher fares. Seems to me that there's an issue of fact as to whether Uber, under those circumstances, is in control of the driver's work.
I don't think so, Your Honor, because we haven't heard any argument about this. It is literally the case that when a driver goes offline in the app, whether they are going on a break, whether they're working for a competitor, whether they're eating, having a smoke, taking a call, whatever they're doing, their time is their own. Uber has literally no opportunity to control an independent driver who is offline in the app. People go offline in the app, and we never see her.
I mean, it's not in the record, but that's not true. You shouldn't argue that because there are plenty of times that Uber can log a driver off for multiple reasons.
Not when they're all, I mean, well, okay, so I suppose certainly it's true that there are people who Uber would not allow to work on its platform anymore.
No, during the day. During the time of that driver driving, Uber has the ability to log a driver off.
Well, I think, but not, I think the question here is when a driver is offline, when the driver says, I'm disengaging the app, I'm severing my...
So let's go back to the argument that my colleague made regarding control, right? Yes. So Uber controls where surges occur and when surges occur, right? So if a driver says, I'm turning off my app because I want to go to a place where it's surging to make more money, that is a level of control, right?
Not over
during the time that the Uber driver has turned off the app, they're turning off the app to be able to go to an area that's surging.
Uber is certainly in control over things like surge pricing, but we're not in control of the workers' activities. And that's the legal question that the Court of Appeals has established. Thank you.
I just briefly wanted to touch on one thing. This presumption that the driver turned the app off. Apps, we all use smart technology. Apps can go off and our phones can freeze. You can lose connectivity. You can run out of data.
That's not those aren't the facts here. Why
No.
don't you address the argument that it's the mere fact of turning off the app is termination at that point of the employee relationship until the app's turned back.
It's absolutely contrary to 100 years of precedence in how we analyze what a person is doing within the scope of their workday. The fact is that it's akin to taking a quick break, that any person who's driving for a living, who's driving for an employer, takes a break. The TNC regulations mandate that drivers have periods of rest. My colleague's citation to the regulation in terms of Uber's insurance is not applicable in the city of New York, which has its own specific regulations in regard to driver.
Thank you.
Thank you.
Highest Company versus Olson.
Good afternoon, Your Honor. Stephen Meister, Seelig and Fine, if it please the court. There are a constellation of, I'd say, about a half dozen facts that the lower court did not appreciate. I want to make sure I bring to this court's attention. First and foremost, the EB5 investors, the Chinese nationals who invested with the EB5 company, initially brought suit against the EB5 company, the defendant here that my client is suing, and my clients. And then they made a deal and they got dropped from that suit in exchange for, and we allege this in the complaint, for promising to sue my client. That's fact one. And related to that, in that underlying suit by the EB5 investors, they claimed that the private offering memorandum that the EB5 fund had prepared incorrectly and inaccurately and misleadingly described the joint.
Tie this into the actual causes of action that we're talking about here, abusive process, because that's really the heart of what we have to decide here. not the tangle of the
Yes,
How does that create a valid cause of action for abusive process?
because,
It's a difficult cause of action to proceed on.
thank you, Your Honor, you're right. We're on an abusive process claim because the court below looked simply at the allegations that the subpoena was abusive and for a collateral.
Isn't that what the court has to do? When you're doing an abusive process, the process that you're talking about here is a subpoena. So that is the very specific question that the court has to focus on.
Yes, Justice Kern, but what I'm saying is that the court failed to appreciate the totality of circumstances that were specifically pled in the complaint.
Let me ask you a specific question. If the subpoenas were an abusive process, why was there not even a motion to quash them in the underlying proceeding?
Well, Your Honor, what I would say to you, the judge certainly did bring that up to me, and there's a colloquy that I have with the lower court on this issue that I would commend to the court's attention that appears at record 28 and 29. There is no case in New York, so far as I know, Your Honor, that holds in any way, shape, or form that a motion to quash, and we didn't bring one, is a condition precedent in any way to
But isn't that some indication of the validity of it? Not dispositive, but some indication that it wasn't an abusive process to issue these subpoenas?
We didn't bring a motion to quash, but what I am and what I am saying actually is that the court erred by essentially holding. I mean, it's very clear from the colloquy that Justice Reed said to me, do you have any cases after the amendment of 3120 of the CPLR to require notice so you don't have to make a motion to bring a third-party subpoena? And I said, Your Honor, I'm fully aware that 3120 was amended in the way you say, and we could have made a motion to quash, but it is not a condition. And so...
Okay, so let's say you didn't make the motion, which is undisputed.
Correct.
Wasn't the court in the best position, since it was involved in the underlying litigation, to make a determination whether it was abusive in that underlying case to issue these subpoenas? Why wasn't the issuing of subpoenas what subpoenas are always issued for, to get information to litigate the underlying case?
Your Honor, I think the simple and short answer is the court just didn't want to hear about an abusive process claim. The court erred in dismissing the claim. The totality of circumstances are very, very clear here.
But counsel, can two things not be true at the same time? That there is some malicious impulse at play while while it being a legitimate process, that being to get information related to the action.
Your Honor, the question is not did they have a legitimate purpose? The question is, did I state a claim? Did my client state a claim?
Let's go back to what you just said, legitimate purpose. I'm so glad you brought that up, because if a party wants information about a case, their claim, they serve a subpoena. You agree with that?
Right.
Okay. So let's say if they want information, let's say to pursue a fraud claim, they can get a subpoena.
Your Honor,
No. Yes, right? No.
Yes.
Okay, so now let's bring it, that's the general, let's bring it now to here. So the claim is they are looking for information about the loans and certain wrongdoing. What's wrong with that?
I will tell you, Your Honor, okay? We were facing, I'm trying to explain the totality of circumstances.
No. What's wrong with that? Because we brought it into the general, now we're going to bring it into the specific.
Because when the purpose of the subpoena, the sole purpose of the subpoena, is to extort an $80 million premature redemption.
But how have you shown that, counsel?
In
light of what my colleagues are saying, that there was clearly a legitimate purpose. They have fraud claims they wish to pursue against your client.
It's not a 3212, Justice Singh. It is a motion for dismissal under 3211. The question is what I have shown. The question is what have I pled. And what I've pled is that I put $30 million into this deal after COVID, okay? I was facing a UCC mezz foreclosure. If I didn't do a deal, they brought a removal notice to the lenders saying that we had committed fraud and willful misconduct, and they shut down those negotiations by that subpoena, by poisoning the well with the lenders.
Thank you. Thank you. You have time in rebuttal to go on, and we are familiar with the record. Thank you.
Good afternoon, and may it please the court. I'm Greg Silbert from Weil for the respondent. As Justice Reed found at page 43 of the record, these subpoenas did, in fact, have a legitimate purpose, and Justice Reed ought to know.
What about your counsel's argument that this is a motion to dismiss, and we really just are supposed to be looking at what's been alleged, not whether or not that can be proved down the line?
Yes, Your Honor. So I suggest that you look at this court's decision in Roberts, which is cited in our brief, and the Second Department's decision in Hornstein. In both of those cases, the plaintiff alleged, like the plaintiff here, that subpoenas, in the case of Robert, or other process in the case of Hornstein, had some kind of nefarious purpose. And to Your Honor's point, in both those cases, the court held no. There's a legitimate purpose for the process because in the case of Roberts, for example, a subpoena is a legitimate interest for a legitimate instrument to collect a judgment. And just as the court pointed out here, we serve these subpoenas to get documents about loans that we allege were fraudulently procured by the appellants here in order to siphon off money to enrich themselves. And to prove that case, we had to find out what these lending institutions knew and understood about the loans that they issued. So naturally, we issued subpoenas to the lending banks. It's clear that those subpoenas have a legitimate purpose, and this court has in the past found as a matter of law that they're legitimate. And
The
that
cases you cite, are those on motion to dismiss or summary?
Yes, they are. They're motion to dismiss, Your Honor. And they're motion to dismiss, and the court says there is no citation needed for the proposition that a subpoena is a legitimate use of process to collect a judgment. Same thing here as the court has already developed with my friend here. We're trying to get information about these loans. Obviously, to do that, we need to issue subpoenas to the lending banks. They really don't have an argument that we shouldn't have subpoenaed them. All they say is, well, these subpoenas, they're too broad. First of all, they were not too broad. They were completely appropriate in all respects. But if my friends thought they were too broad, all they had to do was go to Justice Reed and say, narrow them. That happens every day in litigation. That's a perfectly normal thing to do. Filing a separate lawsuit saying we were damaged by $300 million because you asked for too many documents from some sophisticated investment banks, that makes absolutely no sense.
Were any actual damages sustained as a result of the issuance of subpoenas?
There are no damages that we know of, Your Honor. It's true that they allege. What they allege is that they have to pay legal fees for the bank's response to the subpoenas, but as this court held in the Strzok case, simply paying the costs that arise from the litigation are not damages. They also say they suffered $300 million in damages, but if you look, it's in the reply brief, where do they get that $300 million? It's because the refinancing didn't close. And remember, the refinancing is two different banks. The refinancing is JP Morgan and Monroe Capital. And what they allege is we issued subpoenas to the lending banks, not the refinancing banks. We issued the subpoenas to Deutsche Bank and to Shinhan Bank. And those were not the refinancing banks anyway. So they really have not alleged any damages. They also have not alleged any improper use of the process, which the Court of Appeals held as an essential element in Curiano. This court held the same thing in Geller. All they say after the issuance of the subpoenas is, we took a hard line and we refused to narrow the scope of the subpoenas. Well, what that comes down to is we use the subpoenas to collect documents, which is exactly what subpoenas are for. That's not an illegitimate use of the process. Illegitimate use is like in their favorite case, Farmingdale. There were 87 subpoenas issued requiring the teachers to all show up on the same day of trial so that they were not there to teach, and the school had to shut down. Now, shutting down the school, that is not a legitimate use of the subpoenas. Collecting documents that are relevant to the litigation, perfectly legitimate use of the subpoenas, and if our friends thought they were too broad, they had a remedy for that. I see the white light is on. If I could go quickly to the intentional interference claim. The issue here is that none of the conduct that they allege was directed at the parties with whom they intended to have that relationship, which again is not those lending banks. It is not for their intentional interference claim. It is not about Deutsche Bank and Shinhan Bank. It is about the refinancing banks, which are JP Morgan and Monroe, and all they have for their intentional interference claim is that we issued the subpoenas to the lending banks. And they talk about this letter that we sent about, removing the managing member. First, that letter was sent in January of 2021. They entered into a term sheet for the refinancing in November and December of 2021, almost a year later. So we certainly couldn't have interfered with a proposed refinancing that didn't exist. But anyway, as they concede at page 20 of their reply brief, the letter we sent, just like the subpoenas that they're relying on, all of that was sent to the lending banks, Deutsche Bank and
You want to
Shinhan
address,
Bank.
you don't have much time left, the third aspect of the appeal, the denial of the DJ?
Yeah, so the law of Delaware, which everyone agrees controls here, is 100% clear, and it's spelled out in the Delaware Supreme Court decision called LaPointe. A claim for indemnification does not accrue until the underlying litigation is completed. There's no dispute that the underlying litigation is not complete. These Schick factors that my friends talk about and the energy transfer case that they cite, all distinguishable. Schick is about just sort of DJ claim ripeness generally, not about indemnity.
They're not contract cases.
Yeah, and they're not contract cases. Thank you.
Appellant's contention is that there was absolutely no interest, there never was, in the documents that were sought. That's why the subpoenas were abusive. What they were trying to do and what they succeeded to do, and to go to your question, Justice Singh, we were unable to refinance or to with the existing lenders, and then we were unable to.
But you're, as he characterizes you as his friend, and I will do the same, your friend says that the banks were serving different purposes.
We would have refinanced in the absence of these subpoenas. The banks were very nervous about this lawsuit. We allege, and they said, you got to get that lawsuit dropped or we're not closing. We couldn't close, and by the way, we were foreclosed, and we lost the project. So that's our damages. They succeeded. This was an attempt we had put $30 million in this deal during the virus, and we were facing a UCC foreclosure. We didn't refinance. We tried to refinance with the existing lenders. The poison was in the veins. They said, we don't want to get involved in this lawsuit.
Thank you.
Okay.
King versus City of New York.
Good afternoon. May it please the court. Hannah Sorokin for Appellant, City of New York. Your Honors, the federal release in this action unequivocally the federal release in the federal action unequivocally bars this case, and that was a release that Plaintiff King signed knowingly and voluntarily while counseled.
Counsel, what about the fact that the release specifically refers to and incorporates the settlement agreement, which clearly is not referring to the state litigation, but only the federal litigation? How do you address that?
I just had a bit of a hard time hearing the last part of that question.
I'm sorry, which part didn't you hear?
I couldn't quite hear the last part of that.
The settlement agreement specifically refers to the federal litigation and not the state litigation, and the release incorporates the settlement agreement.
The release incorporates the settlement agreement. It goes beyond that, and the key language here is the omnibus clause of this release releases any claim against the city from the beginning of, I believe the language is the beginning of the world until it was signed in June 2018. And then the first
that one sentence certainly does support your argument. The question is, does the fact that the release incorporates the settlement agreement, and the settlement agreement is very specific, that it's not referring to the state litigation, but only the federal litigation, does that undercut your argument that the release also releases the state litigation?
No, Your Honor, because the subclauses, the first one certainly relates to the federal action. The first subclause says that the release bars any action that could have been raised in the federal action, and that would have been claims, I believe, between 2013 2015. But then there's two additional subclauses that Supreme Court completely ignored. Those subclauses state that the release also applies to any causes of action under the ADEA, which could have been raised up until June 2018 when the release was signed. And the third subclause, any and all other claims that could have been brought, again, from the beginning of time until June 2018.
Would you agree that the arguments you're making, and I understand them, would be stronger if the settlement agreement had not been incorporated into the release?
I don't
because just hear me out. The settlement agreement says it's not related to any other litigation or settlement negotiations. So based on the totality of the documents, isn't it a fair argument to look at it to say that the parties only intended to release the federal claims despite that broad language in the release?
I think the only way to do that would be to ignore the second and third subclauses, which does not align with contract interpretation.
Then aren't you in effect ignoring the settlement agreement, which is incorporated into the release?
Well, no, Your Honor, because there's no dispute that the federal action is the action that was settled, and that any claims that could have been...
Why incorporate the settlement agreement if you wanted everything barred from the beginning of the world?
I think that the key element here is
because I think you would agree that the general release is really broad and would bar the state action, right? That would have done it. So by incorporating the settlement agreement, which is more focused on the federal action, you've limited the general release.
Well, I think it incorporates that, but then it also expands beyond it. I think there's no way to look at all three of those subclauses, even with the incorporation of the federal settlement agreement. There's no way to look at those all three together and give an equal weight, and determine that the release only applies to the federal action because the parties very clearly added more expansive language. They added ADEA claims and did so up until June 2018, and it's undisputed the federal action only concerned allegations from 2013 to 2015.
Thank you.
Good afternoon, Your Honor. My name is Jeffrey Kreisberg, and I represent the plaintiff in this case. At the time the settlement agreement in the federal action was entered into, this state action was pending.
Yeah, but counsel, there is language in the release, as my colleague pointed out, is very broad. I mean, essentially, you're giving up all your claims. All your claims mean all your claims from the beginning of time through the date of the settlement. I don't quite understand why you wouldn't have clarified in the release more expressly or explicitly that you intended not to give up your state claims, but you did refer to the settlement agreement in the document.
Because it was clear from the settlement documents that the settlement documents identified and covered only the federal claim. The state action had completely different claims in it. It was pending when that federal action was settled, and on a motion to dismiss, based upon the document, which is what the city moved for in this case, the standard is that they must conclusively establish that the document signed by the plaintiff was intended to settle both cases. Now, they may be able to...
Would you agree that the general release, if it had not incorporated the settlement agreement, that the general release would bar the state action?
It would be a stronger case for it. I don't know that I would concede that it would bar it, but it would be a stronger case. But clearly, on this motion to dismiss, the settlement papers in the federal case do not in any way conclusively establish that the plaintiff was waiving her rights in this case, and that's the burden. This is not we're not on summary judgment here. This is a motion to dismiss, and certainly looking at the documents alone, without testimonial evidence, it's impossible to conclude that the city has met its burden to conclusively establish a waiver of the state case.
And counsel, didn't the city actually try to settle with your client right before filing this motion?
I'm sorry, Your Honor, I didn't hear
Didn't the
you.
city try to settle with your client right before filing this motion and the state claim?
There were settlement discussions in the state claim. I don't. Yeah, and they were before the city made this motion. While settlement discussions were going on, the city realized what had happened here, and then the settlement conversations ended. What really happened here is obvious. The city forgot about the state case when they settled the federal case. It's patently obvious what happened, but that doesn't help their legal position here. If anything, it hurts their legal position. They didn't realize, or whoever was handling the case and the federal case didn't research properly, wasn't aware that this state case was pending. And that's why it was left out. But it was left out. It was not included, and you can't say on this record that the plaintiff conclusively, clearly waived her right to the state, to her claims in this state case, which were completely different than the federal.
Based on the unequivocal language?
I'm sorry, Your Honor.
I'm sorry, I was out for a minute, but why can't you say that based on the unequivocal language that you released all claims?
Because the documents in the federal case are very specific to the federal case, which was pending.
Then how do we give meaning? How do we give meaning to that sentence?
I'm sorry?
How do we give meaning to that last sentence in the release? You're supposed to give meaning to all parts of an agreement, so how do we give meaning to that?
But it has to be looked at in the context of what was being settled. If there weren't a state case pending, then the day after that federal court settlement, of course, she could not have brought this case. But this case was pending at the time of that settlement. And if they wanted to cover this case in that settlement, there should have been some reference to it in the settlement documents. Simple as that.
Thank you.
Thank you.
Counsel, if I may, let's look at the language of the general release, and I just may paraphrase a little bit, but it does indicate that the action to be taken is going to be done in accordance with the settlement agreement, correct?
Which language are you looking at?
I'm talking about the general release, and that the action, I believe it's at record 91, that the action is going to be taken in accordance with the settlement agreement. You agree with that?
Well, I think what's critical here is
that... No. You agree with that, right? That the action that's going to be taken is in accordance with the settlement agreement.
The settlement agreement only settled the federal.
Okay, but let's go further, right? Because then the settlement agreement indicates that the parties were settling any and all claims as asserted in the federal action as amended, right? Okay, a little bit further, and then it really sets forth what the claims were in the federal action and any unasserted federal age discrimination claims, right? Yes?
Correct.
Okay, and at the time, the state claims were pending.
Correct.
But they weren't mentioned.
That's correct, but I think what...
I'm done, thank you.
Thank you. Thank you. Ritter versus City of New York.
Good afternoon.
Good afternoon.
Please the court. My name is Daniel Ritter. I'm acting pro se, and I may sometimes confuse by saying I or the appellant, but it's the same person. I am the appellant. The gravamen of the offense here is that the appellant was speeding within 1,320 feet of a school zone. The problem is is that there's no indication where the school zone is. The location on the notice of violation, it said Manhattan Parkway. There's no such street as Manhattan Parkway. It doesn't give a number of the building, not a number of the street. It just does not make sense where you can't begin to measure from where the violation allegedly took place to where the school is, where there's zero identification of where the violation took place. That's number one. And number two, on page 15 of counsel's brief, he writes that I had to prove that it was not within the school zone. It doesn't work that way. The burden of proof is for the city to prove to me or to prove to the court that, in fact, I was speeding in the speed zone. Number two, counsel for the city keeps on saying that the burden of proof is clear and convincing evidence or preponderance of the evidence. But that's very disingenuous because counsel says, well, in October of 2023, the legislature rescinded the law that they can confiscate the car, they can seize the car, and that I'm mandated to go to driver's school if I'm found guilty over a period of 6 months or a year, 15 times. But the problem is, all this took place in January of 2022. And at that time, the law said very clearly, not very clearly, the law said very clearly, $50 fine, no points. Then in very small print at the bottom, it says, if you're found guilty 15 times over a year, et cetera, you have to go to school or we will confiscate your car. That already is quasi, if not criminal. They deprive me of my liberty, deprive me of my property. Well, if that's the case, the burden of proof is reasonable doubt, not preponderance of the evidence. Again, on page 28, which is really almost ridiculous, there were 12 NOVs issued to me. 11 of them I was found guilty. One, I was found not guilty. The exact same location, same facts. I pointed it out that under precedent law, if you have a conflicting decision under the exact same facts, it seems to be arbitrary. So counsel says, no, the decision not guilty, that was arbitrary. That's hard to believe. You're saying to me that the judge who said not guilty, that judge was administrative judge, that judge acted in an arbitrary manner. It doesn't work that way. When you have 11 decisions of guilty and one decision of not guilty.
Sir, would you agree that the notices of violation complied with the statute? Here it's VTL 1180B.
Forgive me, my hearing is not that perfect. I couldn't hear you.
Would you agree that the NOLs, notices of violation, they complied with the VTL?
Absolutely not. And I
Why
gave,
is that?
well, number one, there's no description of the car, model, year, etc. Number two, and I have this on pages 9 to 13 of my brief. Number two is there was no person who actually calculated the speeding. It was robo-done. Number three, there's no address. It says location of the violation. College, Manhattan College. That's not an address. It's the name of a university. It could be 10 miles away, 2 miles away. Doesn't tell me anything. And there are various other, from pages 9 to 13, we mentioned the fact that they brought.
Time on rebuttal. Thank you.
I'm sorry?
You'll have time on rebuttal. Your time's up.
Okay, thank you.
That's the red light. Yeah.
Oh, I'm new to this. Okay, Your Honor, thank you.
May it please the court, Your Honors. Jeff Kerfman on behalf of the respondents. Supreme Court properly dismissed this Article 78 proceeding, and this court should affirm. There are a number of claims at issue here. I'll focus on 4 brief points. First, several of petitioner's arguments are not properly before this court. Petitioner did not exhaust his administrative remedies or otherwise failed to preserve his claim for a due process violation, his argument regarding the burden of proof, his argument that an operator did not adequately perform a, quote, self-test, and his argument that the notice of liability improperly omitted the make, model, and vehicle type. The court may affirm regarding those challenges on these grounds alone. Second, the notices of liability identified the correct accident location. The statute simply requires that the notice lists the location where the violation occurred, and the notices here plainly listed the location as south.
How do you address the point saying that just saying something, Manhattan College or whatever the college is just not sufficient?
Your Honor, that's not an accurate depiction of what the notices listed. The notices explicitly list the location as southbound Henry Hudson Parkway at Manhattan College Parkway. That's a discrete intersection. That's a measurable point. And moreover, the technician's certificate stating that this violation occurred within 1,320 feet of a school zone is prima facie evidence of the violation. So it was petitioner's burden to rebut that to rebut that prima facie case. He came forward with no countervailing evidence on that point. Third, regarding inconsistency between the 11 guilty determinations and the 1 not guilty determination, the very case law the petitioner cites states that arbitrary and capricious action can arise where prior determinations are inconsistent with the one under challenge. Here, all of the prior determinations found him guilty. So the case law he cites does not support his point. Finally, regarding the ALJ decisions, the ALJs addressed all of his defenses on both the January notices and the February notices, and he hasn't pointed to any evidence that they did not. If there are no further questions, Your Honors, we'd ask that you affirm.
Thank you.
Frankly, I'm shocked at what counsel just said in response to Your Honor's question about the address. It doesn't say the word Parkway. It says southbound of Manhattan College, period. That doesn't tell you where it is. How can you tell if it's 1,320 feet from a school when you have no idea? Southbound of Manhattan College, there's no such street as Manhattan College, and southbound could be over a period of 5-10 miles southbound. So when counsel says—
The notices don't say the street where the violation occurred? The
sorry?
street number? Do the notices give the street where the violation occurred?
No, it just says location. It says Manhattan College. That's all it says. It doesn't even say southbound. It says Manhattan College. It doesn't say Parkway. It doesn't say that. And if it did say southbound, what does that tell you? Southbound on the west side of the highway, it could be 10 miles worth. Southbound Manhattan College, which is a street that doesn't exist. If any of you lived in the Bronx, you find me Manhattan College. It does not exist.
Thank you.
So therefore, it is impossible for the court to determine that I drove and sped within 1,320 feet of what? Thank you, Your Honor, and I'm sorry for the unfamiliarity with the procedures here.
In regarding 9F Inc. Securities litigation?
Good to go? You want to go?
You're done, yeah.
May it please the court, Your Honor, Joseph Rossello, Robbins, Geller, Rudman, and Dowd for the plaintiffs' investors. We're here today because the decision that we are appealing from is the result of egregious misrepresentations, or rather misinterpretations, of the registration statement. Specifically, we had alleged that there was one statement key here, which is the "we collect" statement that is sprinkled throughout our brief. That statement represented affirmatively that 9F was responsible for collecting all of its fees.
But when we look at the entire structure of that statement, wouldn't it be fair to say that, in fact, it was attempting to disclose risk of the potential decline of service fees?
Your Honor, we would take issue with that, and for two reasons. one is the overall context of the registration statement is really what we're talking about here. So if there's a statement that talks about collecting fees—
But we're talking about the "we collect."
Yes, yes.
That paragraph seems to me, wouldn't you agree, that it's saying, hey, these service fees, they can be reduced, and that's a risk?
Yes, the specific section relates to the fact that fee rates may not be maintained. But that statement is actually not even germane to that issue. The "we collect" statement need not be there for that risk factor. And that's why we think it has independent significance. It's independently material. And the court figured that it was, the company figured that it was, and that's why it's there. If you look at the statement, it is, we earn a substantial majority of our revenues from the service fees that we collect. We being a defined term, meaning 9F, from our borrowers and investors for our loan facilitation services and post-origination services. That's exactly what's at issue here, because Lo and behold, in April 2019, the company had secretly delegated that responsibility to PIC, which is described solely as an insurer.
But why does we collect mean we collect directly versus we collect another way? It's still we collecting. So why is that a misrepresentation?
Well, number one, the we is qualifying collect. So we, of course, again means
Right,
9F.
but whether we collect from one entity or we collect directly, however we collect, we are still collecting.
Well, but the risk and uncertainty associated with the collection is really what's at issue here, because the
But
fees...
isn't that actually stated somewhere in that there is a risk of collection?
No, Your Honor, there's no risk disclosure at all here. That's what makes this a little bit different than NEO, where there was a disclosure that batteries may explode, and lo and behold, batteries exploded. Here, there's no disclosure at all. The only disclosure that they seem to rely on is the idea that business partners may not perform as expected. But that's a risk that could apply in any sense. I mean, a couple months ago, we were here on the C Limited case. There was a similar risk that games may be banned at some point. Well, that's too generic of a risk statement. Here, there's no statement specifically talking to fee collections. And that's really the issue, is that investors don't know that there is this risk and uncertainty out there, and based on this representation, would believe that fees are collected.
Investors don't know that there are servicing fees in many of these transactions?
Excuse me, Your Honor?
That investors don't understand that there will be servicing fees?
No, Your Honor, investors don't understand that someone else is responsible for collecting them. And the reason why that's important is because that third party then takes possession of those fees. Now, investors were already told that the company collects them. The idea that somebody else may collect them, well, the method of that collection is not disclosed. Now, the trial court believed it was because lenders occasionally service loans, not PIC. Again, lenders occasionally did, but 9F also occasionally did, and that's disclosed. So the idea that anyone would even know an insurance company did it. So what we're really talking about is materiality, which is if some third party, any third party collected fees, why does it matter? Well, again, because the funds as of the IPO that were being collected were increasing accounts receivable by extraordinary amounts, skyrocketing as a result of this business change that was not disclosed. 247% in the second quarter, 120% in the third quarter.
You have time for rebuttal.
Thank you, Your Honor.
Good evening, Your Honors. Michael Griffin, Skadden Arps, on behalf of the respondents.
How do you respond to your adversary's argument that the we collect is a standalone, or it can be looked as a standalone, and telling a reasonable investor that we, the company, is collecting?
I don't think it can be looked at as a standalone because it's not a standalone sentence. They've plucked out 2-3 words that are part of a longer sentence that is part of a longer risk warning that has nothing to do with who is making the collections here. As Justice Kern highlighted, the statement we collect could mean we collect indirectly, we collect directly. At the end of the day, they're still the ones who get the money. You know, collect here means receives.
Aren't there certain, I'm sorry, go ahead.
What significance is there that there's no statement about that we're collecting from PICC specifically rather than banks?
Well, it mentioned PICC in that particular risk warning, but elsewhere...
And is that a relevant omission that it's not mentioning PICC?
Not in that particular risk warning, because again, that risk warning is not about who's doing the collecting. It's about the risk that the fee rates themselves could decline, as Justice Singh pointed out in the first argument. That's what that is about.
Is there a disclosure anywhere that, that there's a risk involved when you have a third party collecting the fees?
Yes, Your Honor, I think that there is. Not about the fee collection specifically, but there are two disclosures that bear on that issue. The first, and plaintiffs admit that the offering documents disclosed that 9F charged fees from third parties, including lenders and these insurance guarantee companies like PIC, and that's defined to include PIC. So it's absolutely disclosed that 9F was charging fees to PIC. And then the second disclosure that you have to look at in combination with that is the warning, a general warning, as my friend noted, that any of these contracts with our business partners, with third parties, could be subject to dispute. They could be subject to breach of contract. And counsel's correct that that was a general risk warning, but that's because the risk of breach was general. There was nothing specific that gave 9F any reason to think that PIC in particular was going to breach its contractual obligations here. And that's what distinguishes the C case that counsel mentioned, that I know 4 of your honors.
Is there anything in there to indicate that PIC would be doing any of the collecting of funds? Was there anything in the registration statement?
I would refer back to that same disclosure that 9F was charging fees to PIC. Now, whether PIC was paying that money out of its own pocket or whether PIC was getting money from borrowers and then using that to pay 9F, it really doesn't matter, right? The point is 9F disclosed that it was charging fees to PIC, and PIC was able to pay those fees however it saw fit. And as the case turned out to be, they chose not to pay those fees. They chose to breach their contract with 9F. But 9F had no indication that that was going to happen at the time of the IPO. The only information in this record as to when PIC stopped making those payments is that it occurred in November 2019, which was 3 months after the IPO. Right? That's what makes this different than C. In C, the issue was there was specific reason to think that there may be a ban in India because India had banned other Chinese apps, other apps with perceived ties to China, right? There's nothing specific here to give anyone any pause about PIC's likelihood that it was going to honor its contractual obligations and remit the service fees that it owed to 9F. And that's really the difference here. Between those two. So we think that the trial court got it exactly right. The we collect statement is not about who's doing the collection. It was just part of a larger risk disclosure.
Do you want to address the item 303 disclosure duty?
Yes, Your Honor. So counsel points out that there was this large increase in the accounts receivable in the second quarter, which ended prior to the IPO. That's true. But that's not enough. Simply having what they characterize as a trend or an uncertainty in the terms of those accounts receivable. You also have to allege facts showing that it was reasonably likely that that was going to have an impact on the company's business. And that gets us back to the same place, right? There was no indication that it was reasonably likely that PIC was not going to pay the monies it owed that were currently recorded as an account receivable. An account receivable is just an IOU. It doesn't say anything one way or the other about the likelihood that the person who owes the money is going to make good on it. All else being equal, a large number of accounts receivable is a good thing. It means that 9F was owed lots of revenue that it hoped to collect. Indeed, the fact that it was recorded as accounts receivable shows that 9F did expect to receive it. Otherwise, it would have been the doubtful accounts allowance that would have skyrocketed, not the accounts receivable allowance. And if you look at the fourth quarter, when PIC actually stopped making these payments in November 2019, that's exactly what happened. The company reduced its large account receivable balance. It wrote those off. It took a huge charge to the doubtful accounts allowance precisely because it now had this big dispute with PIC, and PIC was no longer honoring its obligations. And so at that point in time, months after the IPO, it became necessary to reduce the accounts receivable. But standing alone without more, and there is no more here, a large accounts receivable balance does not indicate a problem with that relationship. And that's exactly what Justice Brock found below, and we think that that conclusion was fundamentally correct. So Justice Singh, to your point about item 303, it's not enough just to have a trend or uncertainty. You also have to have facts showing a reasonable likelihood that that was going to have an adverse effect. That's what's missing here. Thank you.
Your Honors, there was a reasonable likelihood of an adverse effect to the tune of $350 million when PIC didn't pay the money. We don't.
That happened after
well,
the IPO.
Well, Your Honor, we don't concede that PIC was not withholding funds before November 2019. We don't concede that. The court construed it against us.
No suggestion that 9F knew that there was going to be this dispute with PIC, right?
Well, Your Honor, it's not really about the dispute. It's about the risk or uncertainty that something could happen when your fees are now concentrated in one institution. Before, what was happening was 9F could go out and collect fees from various lenders. We don't think that...
support that they were putting the risk in one company and that wasn't disclosed? Because the only thing you've referred to is we collect, which again is a very generic statement.
Yes, Your Honor. There were representations concerning concentration of risk. Also, in the description of accounts receivable, there was a description of the concentration of risk, that the way that the company would tell whether somebody would not pay was based on creditworthiness. All of that criteria changed in April 2019 and was not disclosed. The other point I would make is concerning the payment of fees. Pick was not responsible
Wait,
for
how
paying
does that fit into
fees
your claim here that you're actually making in this case?
because that's an additional misrepresentation. The idea that risks, again, are not concentrated. Don't worry about how we collect fees, we collect them. Don't worry about where the risk is.
So you're going back to the we collect.
Well, I go to the we collect, Your Honor, but I think they're all
Just
tied.
wanted to clarify where you're pigeonholing.
Yes, Your Honor. They're all essentially tied there. Also, there's authority for the proposition that when a company discloses one fact, it has to disclose another. Here, they disclose that they stopped charging borrowers in April 2019, did not disclose that they changed the way they collect fees in that disclosure. That was in the registration statement. One last point I'd like to make about who's being charged these fees. There is a statement on R306 about the way the company charges fees. It says that it charges fees as a percentage of loan principal. There is no basis to believe that PIC is paying a percentage of loan principal. PIC gets paid from borrowers, not from collecting from institutions that way. And that's disclosed in the registration statement, that PIC receives a premium when it acts as an insurer. It is solely described as an insurer. We think that was a misrepresentation, Your Honor.
Thank you.
Thank you, Your Honor.
People versus Guante?
Good afternoon, Your Honors. Nicholas Salzberg from Covington and Burling in association with the Office of the Appellate Defender on behalf of Mr. Guante. I'd like to start with a lesser included point. This is a case where the complainant was both punched and stabbed by several men. The prosecution put forth a theory that...
Counsel, what's the evidence of the injuries suffered by the complaining witness here?
So there's significant evidence of injuries suffered by Mr. Rodriguez that were not stab wounds. The first of that is Mr. Rodriguez's own testimony at trial, where he testified to being both punched and kicked along with being stabbed. And that's actually supported in the medical records, which were submitted into evidence, where Mr. Rodriguez said the exact same thing to the doctors who attended to him. The video itself also shows evidence of Mr. Guante landing closed fist blows on Mr. Rodriguez's.
That's not answering my question. I'm asking you, what's the evidence of the injuries?
Well, I was about to get there. The medical records themselves, actually, which were submitted into evidence during Mr. Rodriguez's testimony, and which the jury requested in the first line of their first jury note, have evidence of injuries that were not stab wounds. The first example of that is that Mr.
Medical records before us?
Yes, they're in the record. They are before you, and arguments were made in the reply brief about them. So yes, those medical. Mr. Rodriguez arrived at the hospital with dried blood on his nose, which a jury could reasonably have concluded was caused by a closed fist blow and not by a stab wound.
How many stab wounds did he were reflected in the record? How many slashes, punctures?
It's somewhere in the 16 or 17. Yes. So while those are the most serious injuries, and of course the prosecution put those forth as they were seeking, the highest possible conviction, they weren't the only injuries that were considered by the jury.
Counsel, do you think? Given what happened here, in a nutshell, right? Complaining witness is inside. There's an altercation. He gets hit. Apparently stabbed, something happens inside, he comes outside, there's blood on him. When he comes outside, defendant is there with other individuals, he immediately gets jumped. I looked at the video, I think we all did, and the video, if you pause it in the right place, it seems to show a weapon in at least two individual hands, right? One of them being the defendant. You expect this jury, when the gravamen of what happened here is 17 stab wounds, you expect this jury to parse out the difference as to who inflicted the injury to the nose versus who inflicted stab number 1, stab number 2, stab number 17? Is that really what you expect to get the lesser included crime?
Well, the jury here actually struggled with both Mr. Guante's individual liability for possessing and using a knife and whether he could have been guilty under accomplice liability. In the first two jury notes, the jury asked the same exact question, whether Mr. Guante needed to possess the knife to be guilty for the crimes which he was
That's a
charged.
different question, counsel, because what I'm getting at is with regards to get a conviction for assault in the third degree, you have to show physical injury, correct?
Yes.
And I think undoubtedly here, no one can argue that you could cause a stab wound without a sharp instrument.
I'm sorry, I don't understand exactly what
Would
you're
you think that a stab wound would be sufficient and appropriate as under assault 3 charge for physical injury? Because a stab wound, by its nature, it indicates that a sharp object was used. That elevates it to assault 2.
It's not conclusive, and under the standard here, where the jury where you would have to see whether a jury could reasonably be concluded, viewing the evidence in the light most favorable to Mr. Guante, whether he punched and did not stab. So the fact that Mr. Rodriguez was stabbed.
Are you suggesting that the video does not show it? And incidentally, your client has a white cap on, correct?
He did.
So are you suggesting that the video doesn't show him with a knife or a sharp instrument in his hand making slashing motions?
Yes, Your Honor. The video itself is not clear. It's chaotic.
You don't think it shows anything sharp in his hand? It doesn't show an instrument?
Respectfully, Your Honor, the video is very unclear. It's fast developing.
A reasonable view of the evidence could lead to a jury, which they did, finding that your client was the one with the knife doing slashing movements from the video, correct?
But the jury wasn't charged with viewing the evidence in the light most favorable to Mr. Guante, which this court is charged with. And the jury did express doubts about whether Mr. Guante did in fact have the knife or did act in concert with other individuals when it sent notes back asking questions directed specifically at those questions. So it's...
But that's about the acting in concert portion, right? Not about whether in fact it was assault 2, whether in fact all he did was punch the person.
Well, I think it's implied in the note. If they're asking whether Mr. Guante has to possess the knife to be found guilty, then they are suggesting that there is some doubt as to whether he possessed the knife himself. So that's in regards to individual liability.
Well, that would go to intent, right? And that would go. That doesn't speak. Where I'm stuck at is the injury portion, right? Is there a reasonable view of the evidence here that the stab wounds, right, is only in assault 3 and not in assault 2?
But those weren't the only injuries that Mr. Rodriguez suffered. He suffered. There's no doubt that he suffered stab wounds, and
he suffered 17 of them.
But respectfully, there were other individuals involved in the fight who
What were those other injuries?
I'm sorry?
What were they?
He suffered from a bloody nose, which clearly could have been caused by a close fist blow. He had a CT scan conducted on his head due to having an abnormal gait when he arrived at the hospital, which a jury could reasonably have concluded were caused from
17 stab wounds.
They could also have determined that he got punched in the head, and that was one of his injuries. And so I mean, the injuries the injuries that he suffered that were not stab wounds satisfy the very low standard for substantial pain and thus physical injury, and would support a conviction for assault in the third degree. And we have to remember that the jury, what we're arguing here is that the jury should have had the opportunity to convict Mr. Guante for the conduct that he confessed to on the stand and what made up the entirety of his criminal defense theory. So, thank you.
Good afternoon, Your Honors. May it please the court, Jared Walkwitz for the people.
Counsel, in light of defendant's argument that he didn't have a knife, he didn't know that the others had a knife, and his admission that he punched the complaining witness, and now your adversary saying that there was evidence in the record that came at trial that there was other injuries other than the stab wounds, why not submit assault in the third degree?
Because there has to be a reasonable view of the evidence. What they argued at trial was that there was substantial pain. What they point to in the medical records in the reply brief is blood on the nose. That's not caused by, that's not substantial pain. That's not caused by a punch.
It's my understanding that the complaining witness, in speaking about the injuries, basically focused on the 17 stab wounds.
He did.
Okay. Did he focus on the bloody nose?
He never talked about the bloody nose, never talked about the pain from the bloody nose. And what's more important is that what they cite, the exact quote they cite in their brief is dried blood on the nose. How do you know he just did it? Like, again, we're speculating. It has to be a reasonable view of the evidence. I don't want to speculate. But even their proof, how do you know, like...
But counsel, is it dispositive that the complaining witness doesn't speak about it when it's in the record, it's in the medical records, and that's part of the record?
Well, I'm not sure I understand your question. Is it dispositive in terms of what?
In terms of the assault, submitting the assault in the third-degree charge?
No, because you have to have a reasonable view of the evidence. It's not any evidence. It has to be a reasonable view of the evidence, and we cite that in our...
Why is it unreasonable or not a reasonable view of the evidence to submit the assault 3 charge?
Because there's no reasonable view that the causation here of the pain came from a punch. He was punched, but there was, as the judge said, and I can quote from the judge, he goes, "Are you kidding?" when he talked about that. Because there was no evidence. The 3 things that I want to talk about, the 3 things that they identified in the reply brief is the CT scan, that he got stabbed 17 times. If he had a problem with his gait, that came from that. There was no evidence that came from a punch. He never testified I was dizzy from the...
And a gait in and of itself is not physical injury, right?
What's that?
A gait in and of itself is not physical injury.
I mean, I think what, especially knows, if I came in before this court and said somebody punched somebody in the face and there was blood on his nose, and I said that's physical injury, you would laugh me out of court. You would say, obviously that's not physical injury, it's just blood on the nose. There's no testimony to the pain of it, not the soreness of it, any of those things. And causation matters here. It has to cause the injury. And that just did not happen in this particular...
Well, in this case, what connects the defendant to the stabbings?
As Your Honors were discussing previously, as my adversary was up here, there is a video that shows, when slowed down, that he has a sharp instrument in his hand.
Well, it shows something in his hand.
Right. Well, again, also then, that's not the only evidence. If you look at the video, there's 2 blows. The first blow seems to come from the side. And again, if that's not dispositive, the second blow that goes to the stomach is a side sweeping motion. That would make no sense if you didn't have that, a weapon in your particular hand.
Well, it's not a punch, in other words.
It's not a punch. It's a side swiping motion, not a punch. I mean, his hand may have been still in a fist, but it's not like what we would consider like a straight punch or something.
And in the video, there is a depiction of people who appear to be punching as well, correct?
Well, there are 4 people make contact with him, and as you said, like, you can't slow down and see what everybody's in their hands. But what we do know is that and I think the jury found this, at least that they were acting in concert, and that there is evidence in the record by the video that shows a long thing coming between his fingers. Now, again, the jury, given that where he was hit and the wounds that were taken and the type of motions the defendant had, were well within their right to decide, that defendant had a dangerous instrument in his hand. Now, they didn't have to find that, because if they found he was working with the other people, and there's no doubt that he was stabbed.
Well, let's talk about the acting in concert, because the defendant says, I didn't know those 3.
Well, again, the jury thought differently when they saw on the videotape 2 people left the bar, or got escorted out by security, I should say, went to the side entrance, 1 went in, 1 stayed. Defendant then left with a heavyset man, went directly to the guy in the white sweatshirt, had a conversation. When the 4 came out together, they huddled together. As soon as Rodriguez leaves the bar or leaves through the side entrance, they all attack him. The jury, under these circumstances, and first of all, one other thing is that Rodriguez said in his testimony that the same men who attacked him outside were the same people who attacked him inside. And so the jury had every reason to believe that this altogether made out accomplice liability. And there was enough evidence on either prong to support the verdict here.
Counsel, and I do have a question. There is an allegation of ineffective assistance of counsel.
Yes.
And when you look at the, particularly what I'm disturbed by is the sentencing, where defense counsel appears to just abandon his client.
I would push back on that, Your Honor.
They do.
Because I think that what he was doing was he came into this case knowing that there was this video.
By the way, is it a new attorney?
It is a new attorney.
Okay.
And he came into this case knowing that there was a new, that he was a new attorney, that the court had seen the testimony. And what he was trying to say was he was a minor participant, but he wasn't trying to come in and, act like he had superior knowledge to the court. So the statements that my adversary highlights are just his acknowledgement of the fact that he came in late to the game. But we know that he worked hard because we know that there was a proffer session, or at least the talk of a proffer session. We also know, second, that he sat there and read the transcript. And we know that what he was trying to do makes complete sense. He was trying to say he was a minor participant, which was the defendant's basic trial testimony, right? That he was just punching and wasn't really involved in the altercation in terms of the stabbing. And he made those. And then one statement that he did say, and this is the final thing I'll push back on, is that when he said that it was each one are to be, judged equally under the law, that was true, but that was in the purpose of that statement was obviously so that he could tell the court, look, I know all of them are to be judged equally, but he was a minor participant. And I think that's a way of just acknowledging to the court that I know he's equally guilty, but here's his minor participation, take it in as sentencing.
Thank you.
Thank you.
So under New York law, the most important measurement for whether an individual has suffered substantial pain and thus physical injury is the objective proof of that, and that comes from the medical records. And I'll remind the court that we're under the standard of viewing the evidence in the light most favorable to Mr. Guante. So here it is clear that a jury could see those medical records, which they did request in the first line of their first jury note, and we have to presume they reviewed them closely, that Mr. Rodriguez suffered injuries that weren't just stab wounds. And the video itself is objective proof of that as well. It shows Mr. Guante landing 2 closed fist blows on Mr. Rodriguez. So it's clear that when viewing the medical records together with the video and with the complainant's statements about suffering punches and kicks, that he suffered those physical injuries that were not stab wounds. And this just, it meets it's commonsensical as well, because assault 3 is such a low standard, and yeah, it just meets that under a common sense application as well.
Counsel, thank you very much for your pro bono services.
Thank you.
Vejuno versus MTA.
Good afternoon, Your Honors. May it please the court, Alan Wolin for the appellant. Under Pell v. Board of Education, when we determine whether or not the agency action at issue here was arbitrary, capricious, or in bad faith, we have to determine whether or not the result was justified, And I would like to highlight
the voluntary resignation by.
Well, yeah,
Or I guess I shouldn't characterize it that way. The resignation of your client, and I'll let you characterize it.
Well, yeah, I'd like to discuss that. I mean, that obviously is a threshold issue here. It's, of course, the appellant's contention that his quote-unquote resignation was not voluntary. And I think when we look at all of the attendant circumstances, we have to not only focus on the events that happened on May 8th, 2023, but we have to look at the events that happened in the prior couple of weeks. And I think it's clear that the appellant was deceived, not only on May 8th, but in the couple of weeks leading up to that. It was represented to him that he was taken off his field training because they needed somebody to do administrative work. He was told that he would be put back on field training once there was an opening. He was told there was no opening. He was told not to worry, you know, you'll have plenty of time to prove yourself. So that was his state of mind leading up to May 8th. His state of mind was that he was not going to be terminated, that he would be given time, and that the reason he was taken off field training had nothing to do with his job performance. So then it comes to May 8th, and he doesn't know why he's appearing at this meeting, why he was summoned to the meeting. So he shows up to the meeting, and he's met by 2 or 3 high ranking officials, and he's told, we're going to terminate you. And if you're not going to agree, but you have the option to resign, and if you are not going to resign, then you're not going to get a job again here, and you're going to be terminated. If you resign, you'll be able to reapply and perhaps get another job.
So that doesn't sound coercive.
He was faced.
Does
I'm
that
sorry,
sound
Judge?
coercive? Is that coercive? Doesn't sound coercive to me.
I'm sorry?
Is that coercive?
Well, I think the underlying circumstances were coercive, Judge, because again, we have to look at all of the attendant circumstances. The agency did not act in good faith here. They let him.
Well, okay, let's assume it's involuntary. Then what's the bad faith? What's the bad faith here?
I'm sorry, Judge?
What is the bad faith here?
Well, the bad faith here is the deception in that they lulled him into believing all along that he would retain his job, that it was no big deal. And remember, we have to look at the fact here that the MTA has a policy of not terminating probationary police officers.
Counsel, if I may, can we go back to the beginning, step 1? What, if any, determination did the MTA make in this case? Let's start from the beginning. What was the determination of the MTA? Did they make a determination here?
Did they make a determination?
Yes.
Well, in effect, it was a constructive termination because...
You say in effect?
Well, obviously, the threshold issue here is whether or not we will annul and consider the resignation to be null and void.
No. So it seems to me that you're saying that it appears that they did not make a determination.
Well, I believe they did because when they gave him this pre-printed letter, they had a pre-printed letter.
I see.
They had made the determination that if you don't sign this pre-printed letter, you're going to be dismissed. As far as I'm concerned, Your Honors, that was a determination, and that's a determination that the court can review here. And again, let me just emphasize a couple of points real quick. Every job has a learning curve. He was improving. The field training reports are in the record. We can see that. He was improving. The MTA has a policy, they have a protocol where they do not remove probationary employees,
Counsel, I think that
non-misconduct.
I think that I would agree with you that every job has a learning curve. This job has a learning curve,
Yes.
right? But what they were concerned about was petitioner appeared to have difficulty understanding the appropriate use of force. And then they went on to say, and he had difficulty in that he discharged his weapon in inappropriate times. He's going to be a police officer. That's major.
Well, I beg to differ, Your Honor. I think that was a simulation where they were referring to.
Right, so if you can't get it right in a simulation, if you're not able to get it right in a simulation, and it wasn't just one, it was chances after chances that he had.
But that's how you learn. You learn from your mistakes. Every job, the job of a judge or the job of an attorney, we all have learning curves.
Was he not given opportunities to? Wasn't he given opportunities to get better?
The point is he was improving, and there was no set time limit for him to prove himself. And it was the policy, and he was told, we're going to extend you. We're going to extend you. And here, they terminated him without giving him the proper time to learn. Thank you, Your Honors.
You have time, rebuttal.
There's no point interrupting. You said thank you. He doesn't hear you. Good afternoon, Your Honors. May it please the court. Brian Confino for respondent.
Counsel, it's clearly the person here was given remedial training, right? The argument is that other officers in other instances have been given extended remedial training. That wasn't offered.
That's not accurate. Nobody
What's
else
not
is given
accurate
a
about
second remedial training before.
I'm sorry, I didn't hear you.
Nobody has ever been given a second phase of remedial training or extended the remedial training. And there's no evidence of that in the record anyway, even if.
Counsel, can I just go back to the question that I posed to the other counsel? Was there a determination here? Because I didn't see one.
No, Your Honor. He was given the opportunity to resign in the face of a termination. Had he not voluntarily chosen to resign, then there would have been a determination that he would have been terminated. But as in the record, he chose to resign. He even acknowledged that he resigned. He acknowledged in a letter he subsequently sent to the MTA that he was given the choice and he voluntarily chose to resign. He said, "Since I wanted a chance to return, I voluntarily resigned."
And I cut you off, and, I'm sorry about that. But, I think you'll agree with me. Usually, in Article 78, there's a final determination from an agency that you challenge.
Correct.
And I didn't hear that.
Correct. There was none.
So I'm not even sure why I'm going to stop there.
And as it's normal with this kind of a situation, if somebody's being offered the chance to resign, they come with a letter that was pre-printed that the employee would sign if they chose resignation. If they hadn't chosen that, then the decision would have been made to terminate him, and there would have been a termination letter. But because appellant chose to resign, there was no actual determination on the behalf of the MTA. As that was the first hurdle that appellant hasn't been able to get past. The second was that even if there was a decision, even if he was terminated, there's no evidence that respondent's actions were irrational or arbitrary or capricious. He failed the second phase of his field training, the third phase of field training, the remedial phase of field training. At each of these phases, different officers and sergeants were reviewing his performance, and all of them agreed that his performance was unacceptable. He did the simulator training twice. Both times, the instructors given the training emailed others in the department saying that this officer was not doing a very good job. One of them said that he's instructed over 800 officers previously in the simulator, and he had particular concerns about this one officer. There were half a dozen officers and lieutenants and sergeants who separately gave their reviews of his performance and find it lacking. And even if appellant was improving, he wasn't at the level that he needed to be an MTA police officer. He even admitted himself at a deposition that he wasn't meeting the MTA's expectations at the end of his remedial field training. And equally important, he admitted that the MTA believed that as well, that appellant was not meeting their expectations. Appellant has no reason to believe that any of these reviewers, the 5, 6, or 7 of them, were giving any kind of false statements, were in any way giving a false impression of their review of his performance.
Thank you.
Thank you.
Just in rebuttal, Your Honor, just a couple of points. First of all, counsel says that there was this report and this report and this report, but nobody ever placed my client on notice that you were going to be terminated. There was never any discussion of that nature up until the end. With reference to the simulation, there were emails in the record, memos in the record, but he was never advised of any of that. And again, and I think the MTA admitted this, no other probationary officer had been dismissed in 20 years for a non-misconduct related reason. And this was unheard of in the MTA. And it defies logic to think that no other police officer, no other probationary police officer who passes through the MTA has performance problems and is less than proficient after 3-4 months. They're given the opportunity. My client was not given that opportunity. There was no allegation here that he engaged in any misconduct.
Counsel, if I may, was there any, well, let me pose it this way. Do you dispute the finding that, your client was found deficient in the proper use of a firearm, interaction with the public, and taking steps to maximize safety?
Well, first of all, this is a simulation we're talking about. We're not talking about a real event. And he was improving.
No, but he wasn't up to par in the areas that I just stated.
Well, the issue, I believe, was the timing when he discharged the firearm.
Thank you.
That's how you learn.
Thank
You
you,
learn
counsel.
from your mistakes.
Thank you very much.
That's why they have simulation. Thank you, Your Honors.
Yakti Properties versus Milner.
Good afternoon, Your Honors. Dara Rosenbaum, and Taylor for Defendant Todd Milner. May it please the court, Ms. Rojas. With all due respect, this complaint reads more like a confession than a complaint. It's really a list of regrets and errors and procedural problems with these mortgages. It's not a list of allegations, it's an outline of mistakes allegedly made by plaintiff's alleged predecessor in interest on the mortgages. These points all bring plaintiffs to the point of admitting in their own complaint that they can't maintain a cause of action. There are 4 causes of action in the complaint, 3 of which are not allegations against the defendant or any of the defendants, but in fact are requests for relief by the clerk. So by plaintiff's own admission in the complaint, the documents don't support any of the causes of action, the time in which...
What is your argument now on the documentary evidence, the A1 claim? Is that what you're arguing?
Let's
just, I have a question with respect to that.
Sure.
Have you waived that argument with respect to the 3211A1 motion?
I don't believe so. And not only that, but there's also the A7 argument, which is that it doesn't state a cause of action by its own admission. So we respectfully submit that the defendant's motion should have been...
In your answer, did you assert the claim?
I don't believe that's in the answer.
So then, isn't it waived at this point?
We can
Why
waive
don't you address the A7?
Okay, so with respect to the A7, it's very clear from the documents themselves that are relied upon that they need relief, they need reformation before they can rely upon these documents.
Why can't they proceed with both? Why can't they bring an action for reformation and an action to foreclose on the mortgage in the same action?
Because the statute of limitations of reformation is 6 years, and by any measure.
The statute of limitations has expired, and a different analysis of whether or not a cause of action is stated. And we'll talk about the statute of limitations separately, but now we're just talking about stating a cause of action. What's wrong with the cause of action they stated?
The cause of action essentially says we have assignment, we have an invalid assignment, we have 2 satisfactions that were recorded, and we have a deed that has the wrong location. So I don't know how you state a cause of action when you don't have any of the documents.
But why wouldn't they have a theory that they could, that they have a equitable lien arising from the underlying loan, and that's the basis of the foreclosure?
I believe that'd just be patently unfair. It's been 6 years, 8 years, 9 years, 10 years, 12 years. It's been 22 years since this mortgage.
I'll just sort of call it, did your client pay off the loan?
Not after 2014.
So what's so unfair?
There are 2 satisfactions.
What is so unfair about that?
Because
Your client doesn't pay the loan. They allege that there's an erroneous satisfaction.
2 of them.
2 of them. What's so unfair to your client that they be at least allowed to pursue an attempt to foreclose based on an equitable lien theory?
I say first, he relied upon the satisfaction, and I see my time has expired. If I can just respond to the second portion.
You can respond now quickly, and then you'll have time for rebuttal too.
Okay, I'll take time. I'll take my time for rebuttal then. Okay, that's fine.
Good afternoon, Stephanie Rojas from Leopold & Associates for respondent. May it please the court.
You lower the microphone so you're speaking.
The Supreme Court properly denied the appellant's motion in its entirety. Appellant failed to demonstrate any basis for dismissal pursuant to CPLR 3211A1.
Well, you would agree, right, that statute of limitations for reformation is passed now?
I think you have to look at the answer first in the defense as it was pleaded. In our brief, we argue that the defense is pleaded insufficiently. If you look at defense number 10 in the answer, it just casually states the defendant has a defense of statute of limitations to plaintiff's cause of action.
But put you on notice that they're making that claim, right?
But they didn't list an accrual date. They didn't include any specificity as required by CPLR 3013. And our argument would be that pursuant to plethora of case law, CPLR 3013 requires sufficient and particularity in the way a defense is pleaded. There are 4 causes of action in plaintiff's complaint, and to just generally say as one affirmative defense, the plaintiff's causes of actions are barred by the applicable limitations period is not sufficiently.
Okay, well, let's assume, at least for the purposes of my question, that maybe we disagree with that. Does that mean that you have, you can't seek any relief?
I can seek relief. I could seek reformation, and it can be litigated.
Well, I'm suggesting to you that if we say that the statute of limitations for reformation is expired, in that eventuality, can you still seek other relief?
Yes, we could still seek to foreclose because the mortgage, even if we can't reform the mortgage, our mortgage identifies an address within the property. It's recorded in ACRIS in the public documents against this particular property, not to mention that defendant Mr. Milner made payments after execution of this consolidated extension modification agreement. He paid up until, I believe it was 2014, we note in our complaint, which is reaffirmation of this contractual agreement over and over each time a payment is made. I believe that the statute of limitations is not, it's not a cut and dry issue that we are stopped from reformation. And even if, hypothetically speaking, it was to be concluded that there was a statute of limitations issue with respect to reformation, we could still seek and litigate our relief to foreclose. It's not a cut and black and white issue.
Thank you.
Very briefly, Your Honors, with respect to the statute of limitations issue, I believe that there are 4 causes of action. Only one of them pertains to the defendant. So clearly, asserting a statute of limitations defense was with respect to that cause of action. I would also submit that the remedy would be if to ask for a bill of particulars as to affirmative defenses if there was some unclearness or unclarity
No
there.
dispute here that the SEMA mortgage, that was never, there was no satisfaction issued for that, correct?
There were 2 satisfactions that were filed.
For the original, are you talking about the original mortgage?
For both.
You're saying that there's a satisfaction for the SEMA mortgage too?
Yes. There's a recorded satisfaction of the SEMA mortgage on September 19th, 2010.
So your client continued paying mortgage payments after those satisfactions were filed?
Yes, that's correct. And with respect to the argument that we can seek to litigate the foreclosure, I would just ask rhetorically, what happens next? We seek to litigate the foreclosure with no reformation and no documents upon which to rely. I don't see how any discovery is going to change in that. Thank you, Your Honors.
Thank you.